The substantial questions of law are decided in favor of the appellant and against the respondents. Appeal is allowed.
The consent of the other side, I beg to mention item number 7, that is listed for hearing, my lord. I'm praying for an accommodation only for the day, my lord. Lost may kindly take it up on Thursday, this Thursday. I'll do it. Some difficulty on my part.
Okay, Thursday we'll have to do it. 13
Yes,
matter.
definitely, ma'am. Definitely.
Who's for the other side?
CGSC, my lord. I have informed it.
Okay. Sri B. Sharma, learned counsel for the petitioner, has prayed for a slight accommodation. Full stop. Considering that this writ petition is of the year 2013, matter is a slight accommodation, a short accommodation is granted, directing listing of this matter on Thursday,
18th, my lord.
day after tomorrow.
Much so.
Yes.
May I please? First, I beg to mention item number 10, Lordship. Youngest counsel, Mr. A.L. Mondal is out of station. Matter is the urgent subject.
10 of which year? 16 matter.
Yes.
When is he coming back?
On Friday.
Okay, on Friday, huh? On request, made on behalf of the petitioner. Have you informed finance department?
And
You have to inform first, then make a mention. We are not passing any orders. Inform them first. Yes, next.
I beg to mention item number 15, Lord.
15.
Yes, Lord.
Yes.
Adjournment for 2 weeks, Lord.
19 matter, why 2 weeks?
So, I made to the extent before vacation, Lord. I not prepare, Lord.
No, you don't need 2 weeks to prepare. You are in the court today.
Still, I am in under treatment, Lord.
Next Monday.
Okay, kindly, Lord. I know, Lord. If only after prayer of the Lord, I fix. Kindly 2 weeks, Lord. Fixing it, Lord. Kindly.
Here for whom?
I'm for the petitioner, Lord.
What is your name? What is your name?
Petitioner, Lord.
Okay. Sri B. Sinha, learned counsel for the petitioner, has cited personal difficulties and has prayed for adjournment. Full stop para. Considering the same, list this matter for hearing on 1st of August.
Yes, deep privilege.
18. Yes.
May I please, Lord? My lord, in respect of item number 5, my lord. Yesterday I filed an affidavit in reply, my lord. It may be.
Bring it. Okay.
It is a lot. With consent from
Yes, Mr. Barwa.
6, 5 items. Take to prepare.
Oh no, he wants an item affidavit to be
5 and 6, yes.
affidavit to be called. Nothing to do.
Sometime.
Let us see first.
Yes.
If it doesn't reach
Next
us,
week, Monday, let me file it. If I think today is not possible, then day after tomorrow.
when did you file?
Yes,
Yes,
my lord.
Yes, sir.
Can you bring it today?
Bring it to the.
Otherwise, we can fix another date, Mr. Chaudhary.
Yeah.
Thursday. What are these matters? Series matters.
Contractual workers, they are paying for employees of the.
My lord, so there is a decision.
No.
They are 30 years rendering service. Then decision is taken. This Honorable High Court also says when the posts are vacant to adjust it.
No, we are not on the merits. We are just thinking when to
Yes.
take up the matter. Tell us when.
Day after tomorrow. That's the-
Day after tomorrow? Okay. On request, list these matters on 18th. Affidavits filed in the meantime may be tagged with the records. Otherwise also give the requisition. Which will be item numbers
Five and six.
5 and 6.
I'm for the 5 minutes.
5 and 6.
My lord.
Both are tagged.
Okay.
Five.
18/7.
My lord.
Day after
and,
tomorrow.
My lord, and one similar matter is pending before this court, my lord. This matter may be tagged, my lord.
We have to file the affidavit. Better we have already filed the affidavit.
Similar case.
Now, if it is similar, then why affidavit is required?
Then, my lord, another similar, same issue 2510 also there. You not see direct.
Now, first let us decide these
Yes, yes.
cases.
Thursday,
The other cases will be governed by this. If we are able to come to a decision, it will govern. Okay. Yes.
Obliged.
Mm.
May I please, with consent from the other part, I pick the item number 13
1-3. Yes.
for adjournment.
Here for whom?
Operation Department.
It's 17 matter. Why are you seeking time, madam? 2017 matter. Why are you seeking time?
If my senior G portal is not there,
Okay. Next Monday.
23rd part.
Okay. Next Tuesday. Have you informed the other side?
Yes, for the petitioner, your lord.
Okay. A prayer for adjournment has been made on behalf of the department. Full stop. List on. List on Tuesday. Tuesday hobo hori. 23rd. 23rd. Yes, 23rd.
Much would like to.
May I read your lordship? So I beg to mention for listing lordship. Last listed on 26.
Not before this bench. There is another senior bench free.
May I please pronounce it? I beg to mention item number 8
Hmm.
for adjournment. Because my senior counsel, Kumar Sharma, he left for New Delhi for his treatment and operation and checkups and all. So this matter will
Here for
kindly-
whom?
I'm from the respondent,
Who's not well?
Kumar Sharma, senior. counsel.
Okay. Inform the other side.
My lord,
Yes.
I am for the bit.
But 16 matter, when is he coming back?
Maybe after 4 weeks or within 4 weeks. So 4 weeks and we
4 weeks will be difficult. It's a CGC
3 weeks.
matter. There are other CGCs. It's not assigned to him. We can grant a small accommodation, but 16 matters after 8 years, we cannot grant 4 weeks. You
Why
make
not?
alternative arrangements. Had it been a personal matter would have been different. He's as a CGC. There are other CGCs also. A prayer for adjournment has been made on behalf of Sri S. Sharma Lanit CGC on medical grounds. Full stop. Para, considering the aforesaid aspect as well as the fact that the matter is of the year 2016, adjournment of 2 weeks is granted. 2 weeks.
Item number 10 lordship. I have informed Mr. P. Nayak, lordship, finance
Item number
10.
10.
Yes.
Okay. You have informed.
Yes.
When do you want? 16 matter.
Yes,
When?
on Friday lordship.
Okay. It was Friday, on a prayer made on behalf of the petitioner list on Friday. Friday will be 19th.
Yes.
19/7.
Must-
I didn't want. My lord, we apologize. My lord, we could not find the affidavit, my lord.
Hmm.
It's a very old matter.
Hmm.
Two pertains to 2000, way back 2006.
Okay.
We have written a letter. The
What is the issue about, Mr. Chakraborty?
recruitment, my lord.
I was selected, my lord. I was in the merit list, my lord,
Selected for what?
for the post of supervisor, my lord. Statistical assistant, my lord.
Which
Social
department?
welfare.
Which department?
Social welfare.
Social welfare.
There are
Thereafter?
five posts were advertised. We participated. I was at serial number 5, my lord. My lord, much later I came to know that though I was serial number 5, respondent number 4, who was appointed in Shonitpur district, my lord, he was transferred to my place and regularized against my account. And making so many
The respondent
appeals.
number 4 was a selected candidate.
No. He, I have enclosed the record. He was appointed on ad hoc basis in Shonitpur district, my lord. He was transferred to Hailakandi and he got regularized on the same day, my lord. When I came to know, my lord, through a number of RTI appeal, second appeal and all, then I filed this case, my lord.
Who is for the respondent number 4?
Respondent number 4, justice service was made, then we never appeared, my lord.
Okay, it is
And
complete.
7 and 8 years,
It
my
is
lord.
complete. 4 is complete.
That's
Services.
complete, but that is the last order, last.
Yes, 10-6.
Now, government has not filed affidavit for last 7 years, my lord.
The matter.
Now, at this stage, my lord,
2005,
Mr. Dhar,
my lord.
see,
I understand, my lord.
no, not appointing a selected candidate, you may have good reasons,
Right.
and we may not even interfere.
Right.
But the method which you have adopted of filling up the vacancy by another person who was on ad hoc basis, bringing him and regularizing, that would probably require some
Yes, my lord.
intervention.
My lord. Thing is that I have just
And Mr. Chakraborty, the persons who were above you, 4 persons, they have been
their
appointed.
appointment. I have enclosed the.
You were
appointment
the 5th one.
I'm the fifth. Fourth, I have given the appointment letter, my lord.
Okay.
Now, at this stage, if you lost it, in some cases, my lord, it's been done that respondent number 4 years of the continued for a long time, my lord, without even interfering, my lord, in the department. So,
No, that has to come from Mr. Dhar.
my lord, that affidavit is not being filed in last 7 years, my lord.
Now, if Mr. Dhar takes instructions that you would be accommodated,
My lord.
then perhaps without even interfering with the regulation aspect of legality of the regulation
In
order.
a similar case, my lord, I have enclosed the order also. This procedure was adopted. He was not interested finally.
that part, my lord, yes, my lord. Was even here who's come right.
Then what can be done, Mr. Dhar? Or
My lord, my lord,
you are without any instructions.
I will file an affidavit, my lord. I have spoken just 2 minutes back, my lord. I have spoken over phone, my lord.
It cannot be 2 minutes. It has to be more
My
than
lord,
15.
when mention was
More than
going,
15 minutes.
no, my lord. When mention was going on, once I
2
left,
minutes
my
you are here,
no, my lord.
standing before us.
No, my lord. Yes, yes. That part is correct, my lord. My lord. So, my lord will accommodate some time, my lord. I have spoken, my lord.
See, Mr.
So they
Dhar,
say-
you need not file an affidavit. If you file an affidavit, well and good. But even if you don't file the affidavit, get the instructions in written form.
So whether
Based on that, perhaps, and if you file the affidavit, nothing like that. But the matter, why we are saying you know, because it's a
understand,
matter of 2017
yes, my lord.
and we are in 2014,
2017 and the issue is pertains to 2005
24. How many years? 7 years have passed.
and recruitment is of 2005.
Six.
6.
Why did you take so much of time to come?
My lord,
to
that's why everything, lordship kindly, the fraud is not never done overtly, my lord. I am a selected candidate for getting the merit list, my lord. I filed 5 number of RTI petitions. Then only I got in, my lord. Otherwise, as a selected candidate, why should I not come to court, my lord? This kind of thing is done. Nothing was published, so I thought that I was not selected.
They are even trying to locate records on very old records.
But 12 years you took to come to the court.
My lord, that's why the reason, my lord, fraud is being done, never done overtly, my lord.
Even
How
you-
what?
You have a heavy burden to discharge, to explain the
My
delay of 12
my lord,
years.
they have not filed affidavit. They can't say that I was aware of the thing, my selection. Still, I have not
No,
come.
without even the affidavit, we'll ask you.
Well-
What is your explanation?
My
What is your explanation of 12 years?
explanation I've given, my lord. Delay I have explained because nothing was public, nothing was in the
Does-
public domain, my
So
lord.
you will wait for a time indefinite.
Now, if I am not selected, my lord, if I don't know that I'm selected, how do I think that my right is violated, my lord? Only for select list, I have struggled. My lord,
12 years is too long a time.
Even
1
I-
year, 2 years, 3 years, 4 years,
my,
12 years.
my lord, there is another thing, my lord. The day this.
But we are not on that aspect. If you have taken some decision in other cases, perhaps you can take the same decision. You come up
I
with,
have enclosed the order, my
you have come up, you come up with instructions.
Now he is 54, 55 years.
this kind of thing. 7 years they have not filed affidavit. They are taking, my lord. 7 years they have not filed affidavit. They are trying
My
to
lord,
guard the
even-
respondent number 4, my lord.
That part, my lord.
Yes, 5 years I'll get.
He'll wait for another 4 years,
We-
6
Huh?
years. You are how much? 54?
My age I have to calculate, my lord.
He was 47 when he filed affidavit.
My lord,
This,
victim of illegality suffers like this only, my lord. This
So-
way
so
He'll
only,
wait
my
for another 6 years.
lord.
By
47
the time he
affidavit, my
becomes
lord,
60,
47 and 7 years.
and 7 years, my lord.
54.
Yes, come with all calculation, my lord. That I have
No,
no.
just I read, my lord.
Huh.
54 plus 6 is 60 years.
Well, that much only, at least he would understand that he got justice, my lord. His election is not My lord. That's why, my lord, they can accommodate that way, my lord, in some temporary, whatever manner, they will not know, my lord.
But a admitting whatever you say, let us accept. But selection of 2005, can we enforce it now?
Selected is very
Lordship,
1 year.
My lord, fraud, vicious, everything.
No, so far as the appointment of the respondent number 4 is concerned, we may say something, and that way you are also very fairly you have said that instead
He
of
is also
starting
continuing
him,
long time, my lord. Now
touching
disturbing him, my
but
lord.
whether you have an enforceable right after 12
I
years
have, my lord. My lord, fraud, by
For-
fraud, my,
for a select list.
my lord,
Fraud is qua the regularization of the respondent number 4. Fraud is not for you're not appointing you.
yes, my lord. Number, if they don't fill up the post, I have no right.
They may not fill up the post.
They may not fill up the post.
So it's not,
But if they are
fraud is
adjusted
not,
against my
fraud is
post,
not connected with your non-appointment. Fraud may be connected with the regularization of the respondent number 4.
no, my non-appointment, my lord, if that post is filled up and I am not appointed and someone else
On the
is appointed.
strength of a selection made in the year 2004-5, can we pass an order after 20 years?
My lord, the question of delay will come from knowledge only, my lord.
No,
How
not
do I know,
delay.
my
It's
lord?
not a question of delay. It's a question of enforcement of a select list which has spent its force in 2005.
Yes, my lord. That if
1
they
year.
don't appoint me, it is I have no right, my lord. Being in the select list, I have no right.
No,
But
can we pass an order? Can we pass an issue and mandamus to
I
appoint
think, my
you
lord,
on the
I think
basis of a
if
select
my
list?
post has been filled up in this manner, my lord. My post was filled up. I was entitled for appointment. my lord.
If you make out a case, we may interfere with the respondent number 4, by
No,
which
no,
you
Lordship,
gain,
that is
by
my
which
case,
you
whatever-
gain nothing.
No, I get something, my lord. At least I'll get good, whatever I get, my lord, 4, 5 years, 6 years, whatever.
No. We are not for your appointment. You may make out a case for interfering with the
Respondent number
appointment regularization of the respondent number 4. By that you gain nothing,
By that, I get, don't, no, my lord.
except a moral victory.
My actual course of action would have been if I would have come, my lord, cancellation of his regulation and mine. But since he has continued for a long time, so for the answer of justice, your lordship, my lord, one order I have enclosed, my lord, page 31, same department, he came late. Court interfered in the matter. The government has passed the order, but that order was not interfered, my lord. So he continued for a long time, my lord. Now this man is working now. Page 31.
This is a repetition of 2007,
Which one?
page 31 you are referring.
My lord, that was also very long back
Doesn't matter.
appointment.
Your
I can,
your repetition is 2017.
no, my lord, not the same batch, my lord. Similar situation, what I mean to say, my lord, even if there was substantial delay of the petitioner in approaching the court interfered with the irregularity, but government said that, okay, we are not interfering with the appointment, which has continued for a long time, my lord.
And
I
that is not going to give you any relief. If we make an observation that the appointment regularization of respondent number 4 is not to be disturbed, what relief you get? You get a substantial relief when we have a direction for your appointment.
Exactly.
And to give such a direction, you have to make out a case, a selection of 2005, that too at serial number 5. There is no mandamus can be issued for even appointing a selected candidate. It's their prerogative. Of course, they have to come up with some good reasons
Yes, my
why
lord.
they have not appointed.
Yes, my lord.
Now, if
They
they have,
said they have not appointed. They have appointed in my place,
even
my
if
lord.
the reasons are bad, can we enforce a selection made in the year 2005
My lord, my
after
submission
20
is
after 20 years?
if they do not fill up the post, I have no right. But if someone was appointed surreptitiously, fraudulently in my place, my lord,
No. What
is
is
to go and I
Mr. Chakraborty? There will be a distinction. How are you claiming that it's your place? Is a post
I'm at serial number, merit list number 5.
is a post earmarked for a particular selected candidate? No.
Yes, my lord, my submission, my lord. Yes, if they fill up the post, they cannot.
No. When you are selected, no
I'm
dispute.
selected.
No dispute. You are selected. Can you claim that I am selected for this post?
There are 5 vacancies. I am at 5, general category, and I was not appointed. He was appointed. They can't say that
No,
we did not appoint anybody.
which vacancies?
The 5 posts, 5th post,
Let us see the advertisement.
my lord.
Let us see the advertisement.
Advertisement was not there, my lord.
Then-
That's why they have
So
not
how
signed
do you
anything.
earmark that your selection is in context with a particular post where the respondent number 4 has been accommodated?
Exactly, they should come up with a
No.
something, my
That
lord.
has to be discharged by you. That burden is upon you.
Well, I have enclosed the merit list that they punished me. That shows And the
No,
lordship kindly see the,
by being selected, you do not have any lien, you do not,
no,
there is no
nothing.
lien created over a
Nothing.
particular post, number one. Number two, even if you accept that by selection you are to be appointed, which post do you know that this particular post in this office I have to be appointed?
No, particular post, no,
Then-
fifth post, fifth vacancy.
It's nothing called fifth or sixth vacancy.
My lord, there are 12 selected candidates in the list.
You can maintain a challenge independently so far as the S.P. number 4 is concerned. That how an ad hoc employee was regularized without following the due process.
No, if he's not interfering with my right, I have no right to challenge, my lord. But he is interfering with my right, my lord. That's why I'm challenging him.
Now, how is his regularization connected with your selection? Tell us.
That lordship kindly see, my lord.
Yes, please.
Kindly see, my lord. That appointment of response number, page 28, lordship may kindly see.
2-8.
Regarding response number 4, my lord.
Yes, please.
If actually I'm not correct, my lord, they should file affidavit and contradict it, my lord.
No, why should I? First, you have to convince the court
Yes,
that
my
you have privacy
Yes,
access.
my lord, that is there. It is order, my lord, 2004.
Yes,
Response number 4 was transferred to Shonitpur.
yes,
He was transferred from Hailakandi to
yes.
Shonitpur.
Now,
This
this
is
post,
2004.
No,
this post at Sonitpur, ICDS project Sonitpur,
different post.
against a vacant post, how do you make
No,
a claim?
coming to that, my lord, the
Yes.
order. This is first order. Second one, lord, to kindly see.
Page
Next page,
29.
my lord. The order date, lordship kindly see, 10th February 2007. On that day, all selected candidates were appointed. That I have enclosed, my lord. 10th February 2004. Directly passed this order, my lord, in pursuance of the instruction of the government of the Assam in the social conveyed under dated 7 to 7. The undersigned is hereby pleased to regularize the service of his friend who was appointed to the vacant post of statistical assistant on ad hoc basis by office order dated 2001. So he was regularized on the same day of 10th February 2006 when all the other selected candidates in my batch, my lord, these 5 posts, they are appointed on the same date. Next page, lordship kindly see. After regularizing a Shonitpur candidate, now he has been transferred. Nohanjyoti Borua, Shonitpur, he was transferred to Hailakandi Madi.
Yes.
Director regularized him on the same day the other appointments were made. And on 21st of February, he was transferred from Shonitpur to Hailakandi.
No, we don't find the connection. Date, coincidentally, date is the same. But how do you correlate his regularization? Regulation, we are not saying anything till now. It may be bad in law. His regularization, how do you connect with the appointment of the selected candidate, 4 numbers of selected candidate?
If he was not appointed in my place against the 5th vacancy,
Again, your place.
if it is not correct,
No,
I am not
no,
factually
what is
correct.
the
They
basis?
should come
What
up with
is the-
affidavit.
My lord will just
No,
come to page
just a minute,
26.
Mr. Dhar. We have to know the basis of your claim that the post where he was regularized was meant for you.
Yes,
From where do you get it?
my lord, how can I? That is my statement. Let them say that no, this is not done, my lord. If they say this, I am out of the court, my lord.
See, you are a selected candidate at number 5.
5.
It's their prerogative to fill up or not to fill up. If they do not fill up, they come up with good reasons. We see, examine. But only because somebody who was an ad hoc appointee was regularized, how do you correlate that it is in
The
my
only clue
vacancy?
here is that the date on which the order
First,
was
we do
passed,
not have the advertisement. There were 5 clear vacancies.
page
were there.
27, lordship kindly see,
27.
27.
Yes. Yes.
27 is the 4th Kanu Das, my lord,
Hmm.
who was at 4. I
Hmm.
was at 5, man, in the merit list. Merit list I have enclosed, my lord.
Hmm.
10th February 2006.
Hmm.
On that day, my lord, these appointment letters were issued. And on that day, director is regularized. Director has passed the order, my lord. Same day. Even if I am then my lord, factually not correct, they should come up with the affidavit that is not correct, my lord. 5th post, nobody was appointed.
This appointment, the selection recruitment process was meant for which, for the entire state of Assam?
No, district wise it was made, my lord.
No, where
Selection was done district wise, my lord. It was forwarded by employment exchange.
these 5 posts where you claim to have been selected
My lord.
were meant for which district?
Yeah, Halakan.
Hailakandi.
My lord, page 26.
What is your name? Tapon.
Topon Pal. Page 26 is the merit list, which I got in RTI application, my lord.
My lord will find here there are 12 selected candidates. Not 5.
No, serial number merit list, I got fifth position. That is my case. Five posts. All will not get.
So, my lord, somebody can in number 6 and come and say that I was in merit list number 6. This is a serial list, my lord. We have appointed only 4 people. The 5th one we have regularized, my lord.
The others from 5 to 12 we have not appointed.
Yes, my
No,
lord.
no. 6 to 5 to nobody appointed.
Meaning thereby, my lord, we have from this merit list 1 to 4 we have only appointed, my lord.
Learned friend is submitting, my lord, without any affidavit, without any
My
instruction.
lord, I am placing on
Let it,
document, my lord.
this is my document.
Okay, you come up with instructions, but if you go deep, if its matter is settled, it's good. Otherwise, you may not be entitled to the relief which you are thinking. At least substantial relief, because if you do not get the appointment, you may not be too much bothered with whether we interfere with S1 number 4 or not. Okay,
When
when?
file affidavit, then they're saying so much.
Yes.
My lord.
When?
I will try to do as fast as possible, my lord. My lord will just done with 10 days time.
10 days time. Okay.
7 years
File-
is gone.
Sri B. Chakraborty, Learned Counsel for the petitioner. Para. Sri R. Dhar, you appear as social welfare.
My lord, state council, my lord.
Sri R. Dhar, Learned State Council. However, submits. However, prays for some time to file the affidavit. Para, considering that this matter is of the year 2017,
Date may be given.
comma, 2 weeks time is granted to file the affidavit in opposition, full stop. List this matter for consideration on, we'll have it on 1st of August, Thursday.
Chief development.
Item 2.
It's time, my affidavit is done for waiting, doctor.
What is the matter about?
But as my lord, petitioner's basic pay was wrongly recorded, my lord. It was fixed correctly, but recorded wrongly by respondent number 8, my lord. As a result, he is getting lesser amount, my lord. That is one part. Second part is that, my
You
lord.
work as what?
Yes, my lord.
You work as what? You are
He
working
worked
as
as,
what?
my lord, initially appointed as Khalasi, grade 3 post,
In which department?
in the Central Water Commission, my lord.
Okay.
Thereafter, he was promoted
Okay,
to grade 2 post.
let him file the affidavit.
Okay.
On the prayer of Sri S.S. Roy, Learned CGC, matter is adjourned by 2 weeks.
Doctor, let it be 3 weeks.
Matter is adjourned by 3 weeks. No, don't say like this. Sri S.S. Roy, Learned CGC submits that the affidavit has been prepared and sent for waiting. Para, on his prayer, list this case after 3 weeks to enable filing of such affidavit in opposition. List on, we fixed a date, 19 matter.
No.
List on 8th of August.
Obliged.
Obliged.
Item 3.
Wait, okay. So in this case, I filed a petition for this different salaries in the month of July 2017 till the date of filing. So subsequently, they have received some amount, but what amount they have received, how many have still not paid? They are not clear to me. They are coming in, therefore I need some time to take the.
What is your instructions, paid or not?
Delivery instruction was the month of salary for 7 months already released.
We'll record his submission. We'll record and submission and close this. If from 19, if they have not contacted you, they will not contact you.
Lordship, there is some contract, Lordship, they stated that some amount has not been paid. That was my instruction. So therefore,
7 months you have said.
not from the July from July 2017 till the date of filing, that is 14/8
Current salary they have
2019.
but the present petitioners current salary is not yet released because the
No, we are not on the current salaries. What about the period?
from 17 July 17 my telephone instruction is that released.
Till
From July 17 to 7 months.
7 months. So it is
Their
from,
claim is for 7 months.
no, from July 17 to 14/8 2019.
let us see your prayer.
Yes, this 10 lakhs.
From
No, I have written November, perhaps some amount was
But
paid.
actually they have not received from June 7. My instruction said from June 17.
we close this.
Close.
You are working or not?
Some of the petitioners were appointed in the year 89 also, so I am not clear whether they are still working or they are retired. Some are working.
You heard Sri R. Sharma Learned Counsel for the petitioners. Also heard Sri N.J. Gogoi,
For respondent TN code.
Learned Standing Council. Assam State Marketing, Assam State Agriculture Marketing Board. Full stop. Sri Mr. Chakraborty will be appearing as a state council. Sri A. Chakraborty, Learned State Council, is also present. Para.
Very-
The issue.
I'm not appearing in the agriculture
He also
department.
studying council is there.
Anyone
Yeah.
who's there? R. Bora, is she there? Please inform her.
Okay.
R. Bora, Standing Council Agriculture Department. The writ petition was instituted in the year 2019 with a prayer for for release of the monthly salaries since October 2017. Full stop. As per the projection made in the writ petition, comma, the petitioners were appointed in various posts in the North Lakhimpur regulated market under the Assam Agricultural Marketing Board from the years 1986.
87.
You say written 86, 1986 to 2000. Full stop. Though the salaries were paid initially, comma, there were irregularity in payment of salaries and no salaries were paid since November 2017. Full stop. Para. Sri Sharma, the Learned Counsel for the petitioners, has submitted that he has got telephonic instructions that salaries of some months have been paid. Full stop. He is, however, not equipped with the details of the period. Full stop. Para. Sri Gogoi, the Learned Standing Council, has, however, submitted that as per telephonic instructions received by him
From the secretary, Lakhimpur DN.
from the secretary, comma, Lakhimpur
Regulated market.
Lakhimpur Regulated Market
Market
Committee, comma, salaries to the petitioners have been paid from
From June 2017
June 2017 till
for 7 months.
for 7 months. Full stop. He is, however, not having the rest of the instructions. Full stop. Para. Considering the above facts and circumstances that salaries for some period have been paid, comma, the writ petition is disposed of by directing the respondent authorities to take steps for release of the pending salaries and current salaries if the petitioners are still in service. No, don't believe pending salaries to the petitioners, full stop. The current salaries are also required to be paid if they are still in service.
So regarding current salary, the cabinet take a decision to take PS to all the employees. So let's say only that period. But
Or current or kotha nahi likhiba, pending salaries. But pending, we are making a direction. Have to make a pending salaries. This full stop. The same may be made as released within a period of 6 months from the date of receipt of certified copy of this order. Just a minute. However, a verification is to be made as to whether the petitioners had rendered their service in that particular period.
I think for
Yes, what is this?
Matter related to compassionate appointment. The minutes of meeting, the lordship will find at page number 48, 48P. In pursuance of the Honorable Guwahati High Court order dated so and so,
Who had passed away?
lordship,
Who passed
my
away?
father,
When?
my lord, on 2003, my lord, 14/1/2003, my lord. 14th January 2003.
Then when did you apply?
I have applied on 27/6/2003.
Applied for compassionate ground.
Yes, sir.
Thereafter,
Thereafter, my lord, page 32, my lord, a statement of application on compassionate appointment on seniority basis on the date of application. My name was listed, my lord, and subsequently I have filed a writ petition against my rejection of my proposal, lordship.
where? Page?
The order your lordship will find page number 43, my lord.
By which minutes you were considered?
My lord, pursuant to this order, lordship, my proposal was again taken up for
No,
consideration.
earlier, the rejection was on which date?
Earlier, my lord, the reject
What was the cause of action for approaching the court? At
earlier,
page-
my lord.
Page 43.
Yes, lordship, there was no ground for rejection. my
No, which order, which minutes?
The minute that I'm not available. I have not annexed, my lord. I have filed RTA application, and through RTA, I got the information, my lord, that my application was rejected.
No, rejected when?
Lordship,
Okay, doesn't matter. Okay, then you came before this court.
yes, lordship.
WP
Thereafter, this honorable court, lordship,
WPC, what?
WPC number
6424.
6424/2017.
642417. Yes. What order
Honorable court
passed?
has directed to reconsideration of my application, my lord, and within the 3 months from the date of order. Thereafter, again, we have come before this court with a contempt petition, sir, since the order was not complied
Just a
with.
minute, please.
Yes. That your lordship will find at 46,
To
page
consider
46.
in a period of 3 months. Consider within 3 months. Thereafter, you came for contempt.
Contempt, my lord. Page 46 is the order.
Yes. What is it?
Relevant portion is that 47, my lord. This court has perused the special DLC meeting minutes dated so and so 30/10/2021 and found that the petitioner has been considered by the special DLC and his case has been rejected, my lord.
Hmm.
And the minutes that your lordship will find at page 48P, my lord. Annexure 7. At serial number 2, lordship. In pursuance of the Honorable High Court order dated so and so in contempt case number so and so and order dated so and so in WPC number 6424/2017, the proposal of Sri Manu Gurung was taken up for consideration as per information received from the concerned department. Currently, only a single post of grade 4 Bhandari within bracket is lying vacant. Moreover, the strength of the above mentioned cadre is 1, that is single post, As such, the proposal of the petitioner could not be recommended as per principle 10 15 AV of the office memorandum issued by number so and so dated 1/6/2015, which states that there shall be no compassionate appointment in a cadre having a single post.
Hmm.
This was the reason for rejecting my proposal.
Okay. Yes. Yes, what are your grounds?
My lord, Lordship, this vacancy is pertaining to the office of Executive Engineer Water Resource, Guwahati. My lord, Lordship, may kindly come to page 53. This is the details of grade 4 post under Guwahati Mechanical Division, Water Resource Department, Guwahati. Here, my lord, there are total 58 number of vacancies available as on 21/6/2022. My lord, at the serial number 1, Chokidar 9 number of posts were vacant, and there against this post, my lord, there is a remark also. As per letter number so and so, dated so and so, proposal for filing of the vacant posts has been submitted to higher authority by this office letter number so and so, dated 17/6/2021. My lord, 17/6/2021. That is, my lord, the prior to holding the meeting, my lord. So this shows, my lord, during holding the meeting, my lord, these vacancies were available, lordship.
No, that was submitted. This was submitted on 17/6/2021. What was the outcome of such submission?
Lordship. Yes,
You-
and these posts were vacant, my lord, as on the issuing of this letter, my lord, 21/6.
That is it.
20.
On 21/6/2022, you get a remark
Yes.
that while an earlier letter of 17/6/2021,
Yes,
a proposal was given to the higher authorities for filling up the post.
yes.
What was the outcome of such proposal? Was it permitted?
That
No, this will not be.
and my lord, there are other posts also, my total 58 number of posts were vacant under the grade 4 category.
You are Mr. Jaman.
Yes.
Mr. Jaman, see, the number of vacancies is not crucial. What is crucial is whether these vacancies would constitute 5% of the quota.
Yes, lordship.
Now,
If we count the 58%,
now how do you know that these 58 are entirely there? There is not
Yes.
even a single person who have been appointed on compassionate ground. We do not know the quota of 5% whether it's been filled up or not. Have you made any taken
My
out
lord,
any data?
the memorandum, clause 15 of the memorandum says, my lord, if any particular office doesn't have the available vacancy, then the authorities may consider the other vacancies available under the concerned authorities, my lord.
Not concerned authorities, different departments.
Different departments also.
Now here,
Now,
whether 5% vacancies within 5% quota was available or not, that is the crucial question. And more than that, from 2003, we are in 2024. And first you had approached this court in the year 2017. Why?
application, I have submitted application in 2003.
No, 2003 application, okay. There was a rejection which you do not know when was the date, but you had come to the court in 2017 first. The very essence of compassionate appointment has been lost. Now more than 2 decades have passed.
They spend their post lot as per the guidelines. 1/6/15 lot. Principal plan is clearly stated.
As on date, the entire essence is lost. And the recent judgment of the Supreme Court has gone to the extent that even if the delay has happened because of the authorities' fault, then also you'll not be getting any relief.
My lord, at page 33, there is a statement, ma'am.
33.
Page number 33. Statement showing the details of the application for appointment under compassionate ground in different offices under Kamrup Metropolitan District, Guwahati, as per Honorable High Court order in WPC number 3875 dated
Hmm.
38 2006.
Yes,
Here the applicant in the applicant's list, my name is listed at serial number 7, Lord.
yes,
This statement was as per the Honorable High Court order, my lord,
yes,
dated 3/8/2006.
yes.
So, Lordship, I have pursued the office, my lord, diligently, but
This is in 2006. You came in 17, and here the recommendation was only for one person.
yes, here I was not recommended. No, my lord,
So, Jaman, difficult for competition and appointment. Yes, Mr. Chakraborty, what do you
The
say?
covered case of Debabrata Tiwari case.
Devabrata Tiwari, have you read Devabrata Tiwari?
no, my
You read Devabrata Tiwari, the observations which you have just indicated, that even if the fault or delay is attributed to the department, then also you lose your claim, which indicates that you have to be vigilant in coming to the court. Mr. Sharma, you're for whom?
For what?
You will take the decision.
Okay.
Okay. Heard. What Jaman? MM Jaman.
MM Zaman.
Heard 3 MM Jaman Learned Council for the petitioner. Also heard 3 A Chakraborty Learned State Council and 3 SC S Sharma.
C. Sharma.
Sorry, C Sharma, Learned Standing Council for
I'm carrying on behalf of the RM.
C Sharma, representing the Water Resource Department.
No,
Full stop. Para. The writ petition has been instituted with a claim for appointment on compassionate ground. Please have your seat. Para. As per the facts projected, comma, the father of the petitioner, Go Prasad Gurung, was working as a grade 4 employee in the Water Resource Department at Gwalpara and had died in harness on 14/1/2003, leaving behind his family, including the petitioner. Full stop. The petitioner claims to have applied for appointment on compassionate ground on 27/6/2003.
Yes, ma'am.
Full stop. However, the petitioner could come to learn that his candidature was rejected. Full stop. The petitioner had accordingly filed WPC 6424 of 2017 before this court, in which there was an order dated 27/2/2019 to consider the case of the petitioner within a period of 3 months. Full stop. As according to the petitioner, comma, no action was taken, comma, he had filed contempt case number 154 of 2021, full stop. In the said proceeding, comma, it was, however, revealed that a minute submeeting was held on 30/10/2021, in which the case of the petitioner was rejected. Full stop. The contempt case was accordingly closed on 6/4/2022. Full stop. It is the order of rejection dated 30/10/2021, which is the specific, which is the subject matter of challenge in this petition. Full stop. Para. Sri Jaman, the Learned Council, has submitted that the rejection, though based on the ground that the post of Bhandari is a single cadre post, comma, there were other vacancies in grade 4 where the petitioner could have been considered. Full stop. In this connection, comma, he has drawn the attention of this court to a document annexed as annexure 8. 8 is it?
Eight,
8, which is a part of certain replies obtained by the RTI, and has contended that as on 21/6/2022, 58 numbers of vacancies were existing in the grade 4. Full stop. These are all grade 4.
Grade 4 under the office of Guwahati Mechanical Division. Water Research.
And grade 4 under the office of the Guwahati Mechanical Division. Full stop. He has also submitted that under the notification holding the field, there is a provision
Clause 15.
to consider such appointment in the vacancies existing in any other office, and that exercise has not been done. Full stop. Para. Sri Chakraborty, the London State Council, has however submitted that the deaths of the government servant being in the year 2003, any consideration after any consideration for appointment on compassionate ground after about 2 decades would not be in consonance with the objective of such scheme. Full stop. He submits that though the contention of the petition is that vacancies are existing, the mere existence of vacancies would not be crucial, and what would be crucial is whether vacancies under the 5% quota is available. Full stop. Full stop. In any case, he submits. No, he submits that in any case, the claim for appointment is a stale one and cannot be considered at this point of time. Full stop. The London State Council has also defended the order dated 30/10/2021 by submitting that the reasons assigned are in accordance with law, as the post of Bhandari is a single cadre post. Full stop. Para. Sri Sharma, the Learned Council representing the department, has endorsed the submission of the Learned State Council. State Council order report likhiba Sharma ko order bote. Last line to humai diba. Sri Chakraborty, in support of his submission, has relied upon the recent case of the Honorable Supreme Court in Tiwari, what Tiwari? Vedabrata. Vedabrata.
West Bengal Bharati Debabrata Tiwari.
Vedabrata Tiwari. লিখি দিবা Para. তাৰপিছত আমাৰ compassionate appointment reply লিখিবা খালি এটা লিখিবা the rival submissions have been duly considered. Para. In the instant case, it is not in dispute that the death of the government employee was in the year 2003, and in the meantime, 2 decades have passed. Full stop. The first approach of the petitioner to this court was also after a period of about 14 years in the year 2017. Full stop. তাৰপিছত আমাৰ সেইবিলাক লিখিবা হা আমাৰ বিলাক আছে নহয় গোটেইখিনি লিখিম তাৰপিছত discussion. Okay, rest part we have already there. We are dismissing it. Okay. বেৰা ব্ৰতটো কোট কৰি দিবা
Obliged, sir. Obliged.
Item 22 subjects.
Every lordship. Lordship can be taken up at 2 p.m.
2 p.m. we can take up provided we sit till 2 p.m. There are hardly any matters left.
Otherwise, matter become infructuous, Lordship. There are no interim orders there, Lord. Select list was published,
Yesterday's matter.
Lordship.
What is there? We'll have it after some time. Who will be appearing? You will not be appearing. Your colleague will be appearing, or who will be appearing?
My senior will be appearing, but with, if he is in court number 1, so, or else.
Okay, we wait for some time. Let us see. Okay. Item 9. Yes.
May I please, Lord? My Lord, matter relates to my Lord, detection and abandonment of a Anganwadi worker. What happened, my Lord, in the year 2012, an advertisement was published, and I, along with others, appeared. Advertisement for my Lord, Anganwadi worker, in the against the 27 number Uttar Mohimari Anganwadi. I appeared along with others. 2 candidates were selected.
You appeared?
Yes, my Lord. 2 candidates selected. Private respondent was to task, and I am there. And what happened, my Lord? In that point of time, the private respondent number, although she was selected in serial number 1 of the merit list, she could not join. As because at that time she was a panchayat elected panchayat secretary. I have annexed the document. And on the other hand, she was also in a private school, my Lord.
Okay, she did not join.
Did not join, my Lord.
Okay.
And my Lord, with the approval of the director, another select list published, giving me on the merit list as serial number 1. Accordingly, I was appointed. My Lord. What happened thereafter, my Lord, after 6 months, she, my Lord, respondent number 4, my Lord, here in this case, she filed a case.
Writ petition?
Writ petition, my Lord. And there are many cases were filed in that point of time. My Lord.
What was the writ petition filed by the respondent?
My Lord, you will kindly see page.
Is it 5527?
My Lord, no, my 5527, yes.
Yes. Then?
My Lord, then, my Lord, a common judgment was passed. A common judgment I have annexed, my Lord. The common judgment, the main, my Lord, the direction was that it was directed to the respondent authorities to examine whether, my Lord, their appointment was genuinely appointed or not. Accordingly, as per
common judgment is of which date?
My Lord, judgment was passed on. Common judgment was passed on 26/5/2015.
Yes.
My Lord, as per judgment, my Lord, I appeared before the director. I furnished my every document. Hearing was conducted. Then, my Lord, what happened without giving due consideration in the matter, the impugn order passed.
Where?
My Lord, page 44, my Page 44. And this interim order, sorry, this my lord, impugn order, I have challenged.
Is it 10 to 16?
Page 44, annexure 11,
10 to 16.
my lord.
Please read. What is your name? Parvinara.
Parvina Ram, my lord.
Yes, please read.
Parvina Ram. Now, my lord, whole my lord, purpose of this writ petition, my lord, whether the present petitioner is deciding within the area jurisdiction of the Anganwadi Center.
No, but there was a direction to hold fresh interview. Has it been held?
My lord,
You come to the impugned order at page 44.
my lord. No, my
You
lord.
were released from the voluntary service of Anganwadi worker of so-and-so with the purpose of to hold a fresh interview. Has it been held?
My lord, not held. My lord, you lost it kindly.
After 2016, there was no Anganwadi worker in that center.
My lord, I am working, my lord, as per person to this order, interim order passed by this honor.
Interim order.
Yes, my lord.
Where?
My lord, you lost it, then kindly see page 14, my lord.
Where is the interim order?
My lord, interim order, my lord. Interim order was passed, my lord, until further order was passed, my lord, 11/5/2016. And initial interim order passed, my lord, 16/3/2000. While notice was. My lord, you lost it, kindly go through the judgment, my lord. What is the direction in the judgment? Judgment says, my lord, whether my lord, appointment,
Yes.
whether my lord appointment made, my lord, whether there was, my lord, there is any, my lord, adverse as per law, my lord. But this is the content. Page 40, you lost it, kindly judgment, contents of the judgment.
No, after the judgment, a verification exercise has been made. You have said that after the judgment, common judgment of 26/5/2015, a verification exercise was made. You had
Done, my lord. Verification done, my lord.
you had appeared.
My lord,
And
verification
you
done,
were
my lord.
heard. Thereafter, the impugned order has been passed of releasing you. What are your grounds of challenge?
Now,
Why
my
is
lord,
the impugned order bad in law?
now, my lord, affidavit has been filed by the CTPO, my lord. CTPO says, my lord. Now, my lord, I am reciting with the whole, my lord, the contents of the writ petitioner, respondent number 5. Whether I am the resident of the particular area, my lord, I am reciting there. My lord, affidavit has been filed. I am very much within the locality, my lord. But this is
Affidavit filed by whom?
filed by CTPO.
Where? Page?
My lord, you lordship kindly see page, running page, my lord. Running page 105, my lord. Relevant portion, my lord. Relevant portion, my lord, 108, you lordship. Inquiry report has been annexed.
108.
108. 108.
Yes, please. Yes.
May I read, my lord? Below portion, my lord. The writ petition number 12, so that writ petition, my lord, it was filed by private respondent number 4, my Uttar Purb Mohimari Anganwadi Center number 27. This Anganwadi Center is running temporarily against arrangement in the northeast part of the village Mohimari field. The resident of the petitioner is in the west of the state Anganwadi,
You stay at a distance of 1 kilometer.
my lord. 1 kilometer. And he is, my lord, 30,
300 meters.
300 meters. But at that relevant point, he could not join, my lord. Problem is that, my he was a president, elected president, my lord. And he was running a school, my lord. That's why he did not come. Unfortunately, my lord,
No, whether the private respondent in your case could not join or not, that is not the issue before us. The issue before us is after the remand by this court on 26/5/2015, a verification exercise has been done in which you have been found that your residence is at a distance of 1 kilometer from the center. Don't you think that's a relevant consideration? And the further observation is that there will be a fresh selection process. If you think that you are still within the vicinity of the center, you can participate.
My lord, what happened, my lord? Although, my lord, my residence is 1 kilometer within the village, my lord.
It is not the question of being in the village. What is the entire purpose of being an Anganwadi worker or Anganwadi helper?
My lord, may I submit one thing, my lord? Entire matter may be remanded back to the CTP or director.
Why?
While
It has been
decide,
remanded back by the first judgment, 26/5/2015. 1 kilometer factual position, you are not being able to even, you are not even disputed. You say it's 1 kilometer.
no, my lord. My lord, my resident is, my lord, in the same village, my lord.
What is the, being in the same village is not the crucial factor. What is the distance of your house, of your residence to the Anganwadi center?
My lord, the same village, my lord.
What is the distance?
1 kilometer, my lord.
1 kilometer.
1 kilometer. On the other hand, my lord,
If you say that I stay in Guwahati, you may be staying in Jalukbari, you may be staying in Khanapara.
in fact, my lord, the same
Staying in
village.
Guwahati is not the crucial factor.
Yes.
Where is your residence?
My lord, within a same village, this part or that part, my lord.
What is the distance?
1 kilometer, my lord. That is not distance at all, my lord.
What is the scheme of the entire objective of the scheme to have an Anganwadi center?
Scheme, my lord, within the same village. My lord, I have annexed also, my
Let
lord.
us see. Page.
Scheme, my lord, that is not, I think, my lord, there is an advertisement.
Page.
Page, my lord, translated copy, my lord. Page 13, my lord.
1-3.
1-3, my lord.
Yes.
Physically, mentally. This is not a guideline, my lord. The physics of state sector. And shall be permanent resident of the village of the specific center, my lord. Condition number 1, my lord.
Local female. Where is the vernacular?
My lord.
Where is the vernacular?
Vernacular portion, my lord, page 15, my lord.
Here, there are Goraimari.
Page 15.
অংগনবাদী কেন্দ্ৰৰ খালী হৈ থকা অংগনবাদী
Number 1,
আৰু
প্ৰাৰ্থীসকল অংগনবাদী
স্থানীয় মহিলা
কেন্দ্ৰটোত থকা সকলৰ স্থায়ী বাসিন্দা হ'ব লাগে।
প্ৰাৰ্থীসকল অংগনবাদী কেন্দ্ৰত থকা গাঁওখনৰ স্থায়ী বাসিন্দা হ'ব লাগিব।
That is not, my lord, disputed. I am the resident of that particular village, not disputed. And in this regard, my lord, also, my lord, report has been submitted.
ইয়াৰ দ্বাৰা গড়াইমাৰী নতুনকৈ সৃষ্টি হোৱা স্থানীয় মহিলা স্থানীয় মহিলা প্ৰাৰ্থীৰ what is স্থানীয় মহিলা? Local.
Local resident. Lord, I am serving there, my lord, for last 12 years, my lord. And
Who is for the private respondent?
the private respondent is not appearing, my lord. I have filed, my lord, also, my lord, justice service. I have filed affidavit, my lord. He is not coming. He is a, my lord, now, my lord, as per my information, he is a teacher, my lord. He is not coming, my lord. And you lordship kindly see my justice service. Running page.
No, that is okay.
in this regard, I have also filed update service.
She is a teacher.
My lord, as per my information, he is a Hindi teacher, my lord. May I read, my lord, one, my lord, certificate, my lord?
Which one?
I have annexed in the affidavit, my lord.
Or
My lord, her my lord husband name is Nur Islam. Moi Nur Islam mor ghoror notice loi goisilu. Nur Islam
that is okay. That is okay. We have seen the order. She's been served.
my lord.
Okay. Yes, Mr. Bora, what do you say?
Your Lordship, the only criteria on the basis of which this particular candidature of the petitioner was cancelled, if the Lordship peruses through a affidavit in opposition, internal page 13,
1-3.
1-3.
What is the running page?
Running page, Your Lordship, at that point of time, most probably next page.
No, it's been marked now. All who has filed? Krishna Hazarika.
Yes, Your Lordship, Krishna Hazarika, TTPO, Goromari SPS project. I'm taking Your Lordship straight away to that particular.
My lord of 70.
To the letter dated 14th of December,
Just a minute, please.
speaking out.
Internet page.
The running page I have been told is 70.
70. Yes, yes.
With regards to that particular rate petition,
Oh, that was by Sajida Khatun.
Yes, my lord.
Number
That-
4. Who
Yeah.
number?
Yeah.
5527.
yes, Your Lord.
Yes.
So the petitioner filed in that particular case, petitioner filed a writ petition claiming that although she stood first position in the first position in the interview, she was not selected for the post of Anganwadi Worker Center. That then CTPO of Goromari SCTS project informed that the petitioner, Srimati Sajida Khatun, was an elected member of Kuprapara Gaon Panchayat, and she was working as the president of the state Gaon Panchayat at the time of issuance of the engagement letter order. She did not even resign from the state public post even after publication of the result. As such, to functionaries the Anganwadi Center, the respondent Parvin Ara Begum, who served in second position in the interview, was engaged as Anganwadi worker. The present CTPO officer in the report stated that a resident of the respondent, Srimati Parvin Ara Begum, is not within the concerned Anganwadi Center area. Therefore, a fresh interview of selection to the post of Anganwadi worker may be directed. Thereafter, we were directed to furnish that particular inquiry report also. So why we share actually my learning friend had shown you also, saying that Parvinwara Begum, who is the respondent, is approximately 1 kilometer west of the Anganwadi Center we are running now. So that is the basis on which it was rejected. And as per the advertisement also, of course, I agree that it should have been under the revenue village at that point of time. But thereafter, that guideline undergone a change. After 2013, has to be within the limits of the Anganwadi Center.
Yes, where is it?
There is a guideline to that effect.
Where is it? Is it annexed?
It is not annexed.
That is what we are remembering, that it has to be in the same locality.
Local. It is within the same Anganwadi limits of the Anganwadi Center. Because in the same village, there might be 2 Anganwadi centers also. So that has changed because there was a division bench judgment of 2017, if I remember.
Mr. Boda, what now transpires is that first the tussle was between the private respondent and the petitioner. Private respondent, in spite of being number 1, petitioner was appointed. That was the subject matter of challenge, and it was decided along with many other cases. Separate considerations were there, and matters were remanded. In the remand, so far as not giving appointment to respondent number 4 was concerned, that has been justified. Because he was holding some Gaon Panchayat post. But at the same time, whether the petitioner is entitled to be appointment, even that has been gone into. And it has been found that she is not within the concerned Anganwadi Center. Now, this is one of the findings, and in the inquiry, the specific finding is that her residence is at a distance of 1 kilometer. Now, if there are no other Anganwadi centers within that locality, whether 1 kilometer itself would be an embargo or a absolute bar not to
Yes.
appoint her.
That of
And
course,
on the same time, in the same time, she's continuing.
that is the question, Your Lordship. Now that I have to actually find out.
Yeah, had
whether-
it been the between two persons, now for obvious reasons, the respondent of 4 is not contesting. She's not interested. And she was not even interested in the first rejection. She could have filed another petition.
Yeah. Now the whole issue as such right now delves into that particular sole question, whether that bar of 1 kilometer,
Yes, yes. No, no, whether 1 kilometer would be a bar
whether 1
or
kilometer.
whether the locality can be here, can be confined to a area which is less than a kilometer or maybe more than a kilometer. Because the main purpose or objective is that the center should run smoothly. The persons who are manning the center should be within such a limit distance wise that anything needed, she is in the center. And in most of the cases, we find that even the worker or the helper in her own residence, the center is there.
He otherwise is protected right now by the interim order, 2016 onwards. He has been enjoying the interim order.
Are you working, Mr. Manaf?
Yes, my lord. Till today I am working, my lord, without complaint, my lord.
Without complaint.
Without complaint, my lord. My lord, as per my lord guideline, my lord, he should be, my lord, a resident of a revenue village. My lord, that's okay, my lord, in the advertisement.
Now, in the affidavit, Mr. Bora, have you stated anything that being within a kilometer would be a disqualification?
There, as such, that it is not written in the additional affidavit or the affidavit.
Affidavit, nothing is there.
Not.
At the same time, we don't want to lay down something that 1 kilometer would be
Yes.
okay.
Yeah.
Because it's ultimately your prerogative.
Yes.
Your prerogative and exercising in your discretion is to ensure that that the lady is within that vicinity.
But otherwise, the advertisement as such would say that it is within the revenue village at of 2007.
1 kilometer is not too much also.
I believe right now, of course, the applicable guideline as of 2007 would apply because the advertisement is of 2007.
Yes.
And that, as per that guideline, of course, the revenue village was the criteria. That I agree. After that, it changed.
Okay.
It should be within the limits of the Anganwadi center. Perhaps they might have got confused with the new guidelines and the old guidelines.
Okay. Heard. Sri A. Manaf, Learned Counsel for the petitioner. Also heard Sri D. Bora, Learned State Counsel, representing the official respondents. Full stop. Though the respondent number 4 has been served, comma, she has chosen not to contest the writ petition, and in this regard, there is an order dated 20/11/2020 of this court that the said respondent number 4 has been served. Para. The issue involved is the selection and appointment of the petitioner as Anganwadi worker within bracket AWW. Para. As per the facts projected, please have your seat. In the year 2000, as the facts projected, comma, in the year 2012, a recruitment process was initiated for filling up the post of Anganwadi worker of the newly created number 27 Uttar Pub Mohimari Anganwadi Center under the Goroimari ICDS project in the district of Kamrup. Goroimari is in Kamrup,
Yes, sir. Kamrup rural, but
not Dharam district.
not. The Soigao, my lord, Soigao area, my lord.
But Sipaza side, there is some Goremari, I think.
Maybe
Sipaza.
maybe my lord, but it is my lord, Kaigawari.
Okay, Goremari, I see, in the Kamrup rural. In the said selection, comma, the petitioner had participated and was subsequently appointed, full stop. The said appointment was, however, the subject matter of challenge by the private respondent number 4 in WPC 5527 of 2012, full stop. The said writ petition was disposed of along with a number of other cases pertaining to challenge to appointment of Anganwadi worker and were disposed of by the common judgment dated 26/5/2015. Full stop. Full stop, 15, by which the matters were remanded to be examined afresh. Full stop. The petitioner had appeared before the authorities. Full stop. However, vide the impugned communication dated 10/2/2016, comma, the petitioner was released from the post of Anganwadi AWW with a direction to hold fresh interview for the said post. Full stop. Para. Sri Manaf, the learned counsel for the petitioner, has submitted that the impugned order has been passed on irrelevant consideration, full stop, by drawing the attention of the court to the document annexed to the affidavit in opposition filed by the respondent number 3, comma, the learned counsel for the petitioner has submitted that while the candidature of the private respondent number 4 has also been found fault with, comma, there was no reason to find fault with the candidature of the petitioner. Full stop. It is submitted that the only reason assigned is that the petitioner was having her residence at a distance of 1 kilometer from the Anganwadi center, which is not relevant. Full stop. By referring to the advertisement, comma, the learned counsel has submitted that the requirement was to be from the same village, and there is no dispute that the petitioner is a resident of the same village where the Anganwadi center is located. Full stop. Para. Per contra, comma, Sri Bora, the learned state council, has submitted that the impugned order dated 10/2/2016 is only a consequential order of the decision taken by the authorities after the matter was remanded for a fresh consideration. Full stop. The state council submits that the candidatures of both the candidates were rejected by citing good reasons and with a further observation that fresh selection was required to be made. Full stop. The state council accordingly submits that the reasons being prescribed and being relevant, comma, no interference may be made, and the post may be permitted to be filled up by a fresh selection. Full stop. Para. The rival contentions have been duly considered. Full stop para. This court has noticed that wide an interim order dated 16/3/2016, comma, the impugned order of discontinuation from service has been stayed. Full stop. The learned counsel for the petitioner has also clarified that pursuant to such interim order, comma, the petitioner is continuing in her service without any blemish. Full stop para. The initial writ petition by the respondent number 4, namely WPC 5527 of 2012, was instituted challenging the appointment of the petitioner in the aforesaid post. Full stop. The said writ petition was disposed of by remanding the matter back for an examination by the authorities. Full stop. The relevant document which has been annexed in the affidavit in opposition dated 18/8/2021, filed by the respondent number 3, would reveal that while the respondent number 4 was held to be disqualified as she was holding a post in the Gaon Panchayat, elected representative or what?
My lord, elected.
As she was
I have-
an elected holding a post there, as she was an elected representative of the concerned Gaon Panchayat, comma, the candidature of the petitioner was also found fault with on the ground that her residence was at a distance of 1 kilometer from the locality. Full stop. The concerned advertisement and the rules holding the field at that time stipulated that a candidate should be from the same revenue village. Full stop. Sri Bora, the learned state council, has fairly submitted that though subsequently there is a change in the aspect of the residential aspect, comma, at that time, comma, the requirement was to be from the same revenue village, and full stop. The documents, the materials on record would clearly show that the petitioner belongs to the same revenue village where the concerned Anganwadi center is located. Full stop. Para. In view of the aforesaid facts and circumstances, comma, the factor of distance which has been taken into consideration may not be a relevant factor so far as the present selection and appointment is concerned. Full stop. As noted above, comma, the petitioner is continuing in her service on the strength of the interim order. Full stop. Para. In view of the above, comma, this court is of the opinion that a case for interference is made out on the peculiar facts and circumstances. Full stop. The impugned order dated 10/2/2016, by which the petitioner was sought to be released from her service as AWW, is accordingly set aside, and the petitioner be allowed to continue in her service as AWW in the aforesaid Anganwadi center. Full stop. The interim order dated 16/3/2016 accordingly is made absolute. Writ petition is disposed of.
Apply.
No, dispose of writ petition accordingly stands allowed. Yes.
My lord. I was also ready for hearing, but from the record, I checked that one page of the one annexure is not there, so I may be allowed to correct that.
What is the matter?
I was undergoing training in the CRPF, and in course of training, I was terminated on the ground that in the verification role, I had suppressed the fact that I was involved in PS cases,
In
in criminal cases.
criminal cases, okay.
To that effect, Your Honor, had submitted by appeals also.
Okay. Okay, madam, you are for whom?
I'm from CCC London, Deca, and he's on his legs. Kindly
Okay.
after some time.
No, he wants to change a page, insert a page. There's some defect in the. Okay. How much time, Mr. Moria?
And it may be taken on 24th.
Ready for it?
24.
More so, my lord, when the cases were involved, at that time I was minor, and I have two judgments on that.
Heard, the 3HL Moria Learned Council submits that there is some discrepancy in the documents which he would
I will insert in the, along with annexure 2.
documents which he would rectify within a short period of time. Put stop. Consider para. Miss, what is your name?
P. Burwa.
Miss P. Burwa Learned Council is present on behalf of Sri B. Deca, Learned CGC. Para. Considering that this writ petition is of the year 2016, a short accommodation is granted, directing listing of this case on
24th
24th of
this month.
July 2024, by which time the necessary rectification be made.
My lord, in para 2, there is one typing mistake of date. One should made 8. I may be allowed to correct it.
That would be difficult.
My lord.
You have to file application. These are all matters, all inserted in the CIS system. Best you file an IA, will have everything on record.
Along with that, I will file it.
Make please, Lord.
Yes, what is this?
Milord, non-grant of financial upgradation, Milord, in terms of the STP and MSTP, Milord, the subject matter in dispute, Milord.
Mr. Bora, you'll be there
Sir.
as CCC.
Sir.
Oh. 4626.
Milord, Tasban Leo Singh, Milord, he was appointed as a constable in the year 1983, Milord, in CISF. 1983. 01/01/1983.
1983, appointed as
Constable, Milord. He retired in the year 38/2018, Milord.
as constable in CISF.
In CISF, Milord.
Retired when?
38/2018, Milord.
3818, retired.
Yes, Milord.
Okay.
Now,
Retired after filing of this case.
Lordship,
Retired after filing of this case.
before filing of this case.
No, you filed this on 16.
2016, Milord. 18, he retired.
After filing.
Oh, so yes, Milord, after filing.
Yes.
Milord, MAECP Assured Career Progression Scheme, Milord, was introduced, Milord, in CISF in the year 1999, Milord. Lordship may kindly peruse page 15, Milord, of the report.
Page
Page
15.
15, 15, Milord, the next one. So, may I read?
Just a minute, please.
reference UP so and so regarding ACP and MSP respectively also refers CIS of headquarters letter. Second is important. ACP scheme came into existence with effect from 9/9/1999, envisaging granting of two financial upgradation to a next higher scale in the existing hierarchy. First financial upgradation will be granted after completion of 12 years, and second financial upgradation will be granted after completion of 24 years of service. Eligibility conditions for sanctioning financial upgradation under ACP scheme were under attaining prescribed benchmark.
Yes.
Attaining prescribed benchmark, qualifying PCC, promotional cadre course miller, PCC stands for.
Yes.
And step one categorization, this is physical health, fitness.
What is PCC? Qualifying in PCC?
Promotional cadre course miller.
Okay,
And step one is physical health.
understood.
In case of non-fulfillment of the above condition, granting of financial upgradation would be delayed till such time an individual fulfills the same. Any such delay in granting first financial upgradation under the ACP scheme was also having a consequential impact in granting second financial upgradation under the ACP scheme to the same extent. Consequent upon implementation of the Sixth Pay Commission, the ACP scheme has been modified with MSCP scheme, which came into existence with effect from 1/9/2008. The MSCP scheme emphasizing granting of three financial upgradation to the immediate next higher grade pay in the hierarchy of pay basic and grade pay. First FUG would be granted after completion of 10 years of service. Second FUG would be granted after completion of 20 years of service. And third FUG would be granted after completion of 30 years of service. In MSCPs, only fitness benchmark is applicable for granting financial upgradation, and other conditions like qualifying PCC and attending step one categorization as applicable to ACP scheme have been discontinued. In case of not attaining the prescribed benchmark in MSCP due to indifferent service records, granting of financial upgradation would be delayed till such time an individual fulfills the same. Any such delay in granting first, second financial upgradation under MSCP scheme will also have a consequential impact on the second and third financial upgradation under MSCP to the same extent. Since the two conditions, qualifying PCC and attaining step one medical categorization, which were essential for financial upgradation and ACP scheme, are no longer required to be followed in under MSCP scheme, the aspect of having consequential impact of different FUG under MSCP resulting due to delay in qualifying PCC attaining step one would not have any consequential differing impact. Second and third financial upgradation under MSCP, so long as they are not the prerequisite in granting MSCP. However, any delay in granting ACP benefit due to non-attaining of the prescribed benchmark or due to departmental process, etc., will continue to have a consequential impact on subsequent MSCP benefit to the same extent. The steering committee will continue to assess the fitness of the individual in accordance with the present system of marking as conveyed in circular number so and so and so and so. This is that.
Yes.
Now, for ACP, as Lordship has seen, Milord, what is required, Milord, is 12 years of service, Milord, and there are three
Criteria.
criteria, Milord. So far as, Milord, the criteria of qualifying PCC is concerned, Milord, a candidate is given three chances, Milord, and four in exceptional circumstances. Lordship will find this in the affidavit in opposition filed by my learned friend. Lordship may take up that for a moment. This is the first page 39, Milord. Affidavit in opposition, Milord. Annexure H.
By Sunil Kumar,
Lordship? Yes, Milord. Affidavit in opposition by,
Raghuvanshi.
yes, Milord. By Sunil Kumar. Raghuvanshi. Page 39, Milord. CIF circular number.
Page
Page 39, Milord. Annexure is last page, Milord. Okay.
Yes, which one?
39, Milord.
Yes. Where?
Circular number 39 of 1990, Milord. In continuation of CIF, the circular number 15 of 1990 on the above mentioned
No,
subject.
the pages are varying.
Lordship. Annexure H, Milord.
Annexure
H.
Page.
Yes, sir. Last page, my lord. Our circular number 39 of 1993, my lord.
Just a minute. This is page number 72.
Page number 72. Yes, sir. Now, this continuation has come up.
Okay.
Okay.
Okay. Yes. This is circular dated 23/26, 11 of 1993.
Circular dated, circular number 39 of, yes,
Oh.
26/11/1993.
Yes, yes.
20 dot.
Yes.
In continuation of CIF circular number so and so on the above mentioned subject, it become imperative to review the promotion cadre course failure policy at FHQ in view of a large number of failures being reported from different training institutions in the promotion cadre course in various ranks, that is from constable to inspector. I has now been decided after due consideration that henceforth third chance will be afforded to those persons who have not been able to clear the promotional cadre course after availing the second chance. However, in exceptional cases, only fourth chance would be given by only IG headquarters at FQ on special recommendation from the concerned DISG. While recommending for a fourth chance, concerned DISG will have to justify the reasons for such recommendation.
Okay.
So, Miller, to qualify PCC, a candidate is given three chances. In my case, what happened, Milord, in the year 2000, I have all other benchmarks, Milord, except I failed in PCC. So, in terms of this circular, Milord, I was to be given three chances that was denied to me. I have a, Milord, authority on that, Milord, which says that you cannot deny the benefit of ACP to a candidate who failed in qualifying PCC unless he has completed his three chances. So this is my first limb of argument. If you lost it,
The third chance has not been given to you, was not given to
no,
you.
I was given the three chance. In third chance, I qualified. Milord. If I qualify ACP for ACP, Milord, I qualified in the year 2000. It's an admitted fact. However, in the three prescribed conditions, 12th year I have four prescribed conditions. 12th year I have services, Milord, attending benchmark that was there, qualifying PCC I failed. Take one categorization I was having. So because I failed in qualifying PCC, ACP was denied to me, Milord, in the
Yes.
year 2000, Milord. In my humble submission, Milord, that is a wrong understanding, Milord, and that needs to be interfered.
No, see, when you had read out both the ACP and MACP,
Look.
first there were the concept of having two financial upgradation.
Look.
And when do you have to have financial? After completion of 12 years and after completion of 24 years. But this is only the qualifying period.
Look.
Become qualified to be considered.
Look.
Now, to be considered and given the benefit, you need to fulfill the three factors.
Look.
Not fulfilling even one of the factors will not make you eligible to get it.
There I may differ with your lordship, Milord, only because, Milord, as per their own notification, three opportunities has to be granted, Milord, to qualify PCC. That is what the Delhi High Court says, Milord, division bench also, single bench also, and that is with respect to CISF only, Milord. So for same personal, Milord, there cannot be two different sets of law. I am also a CISF personal. The judgment that we are referring to is also with related to the CISF. It says that, Milord, as three opportunities has to be there. Even if I
Three
fail in PCC,
opportunities for what?
three opportunity to qualify PCC, Milord, promotional cadre course, Milord.
Did you qualify?
Yeah, I qualified. That is there in the affidavit itself, Milord. Lordship may take up their affidavit, page number. Page number 18, Milord. It will be paragraph number 14, Milord. Just before paragraph number 14. Affidavit in opposition filed by them. They also admitted position. 2000 I failed, 2004 I failed, I qualified in 2006, Milord. Third attempt.
Page?
Page number 18, Milord. They will change the page number, Milord.
No, internal page.
Internal paragraph 14, my lord, is the internal page 18, my lord, of the affidavit. And
Yes.
paragraph, just above paragraph 14, my lord.
Hmm.
The petitioner again attended PCC in 2004 but failed to qualify. He finally succeeded in qualifying PCC in 2006, my lord. One more, my lord, paragraph I would.
No, if their understanding,
Yes, my lord.
you have succeeded in qualifying the PCC in the year 2006.
Lord.
So what is the impediment?
Lord.
What is the impediment? Why not? Why have not?
My
Why
lord,
haven't they
they
given?
again considered me in 2006 for grant of ACP. In this time, they again considered my ACR, my lord, of 5 years from 2005 onward. That also I will, my lord, that will be a second limb of argument, my lord. There also I qualify, my lord, but according to them, I did not qualify because there were 3 punishment imposed upon us, and I did not score the benchmark on that in that year, my lord. But my first limb of argument is, my lord, when I qualify in 2006, my lord, I would be entitled to ACP from 2000 onwards, my lord. This is my first limb of argument. The second limb would be, my lord, if not, then from 2006 also the calculation is wrong. That will come.
But 2006, they said that you do not qualify in the ACR component.
Lord,
So how do you overcome that?
my lord, they have calculated one punishment which according to their rules is not a penalty, my lord. One is that the calculation that they have it was also wrong. That will come, my lord. Only one line if your lordship can, I can, my lord, take your lordship to, my lord, paragraph, internal page 10, my lord.
Of
Par-
your
of their affidavit of obligation, my lord.
Hmm.
Internal page 10, just above paragraph 6, my lord.
Hmm. Yes.
Uh, 7 lines from the of paragraph 5 from the at page 10, my lord.
Hmm. Yes.
He further undertook that he would forego his promotion and would not claim later on, my lord. Was there one word, what was, it was there, and one word, my lord, he could not take, no, that is, one second, my lord. Not this. My lord, yeah, it was the same paragraph. My lord, what was there, my lord, we will take your lordship to that, is that my unwillingness to take the PCC, my lord, due to some personal difficulty, my lord. That line was there in their evidence on the lord. I'm not finding it. We'll take the lordship after. In this fact, my lord, I placed one judgment, my lord, of the Delhi High Court, my lord. It is, there are 3-4 cases that are in marked here, my lord, on the same line and then. 2013 SST online, my lord, Delhi 2937. Karam Singh versus Union of India. This matter relates to the CISF only, my lord. Page 3, my lord, paragraph 1 we speak.
Which paragraph?
Milord, paragraph 1, Milord. Let us start with paragraph 1.
Yes.
Page 3, Milord. The petitioners seek in this case restoration of the first financial upgradation as per the Astute Career Professional Scheme herein after referred to as SP with effect from 17 February 2004 when he completed 12 years of service with the Central Industrial Security Force, hereinafter referred to as TISF, and become entitled for grant of first financial upgradation in the grade of head constable under the ECP scheme and grant of second financial upgradation under the MSP with effect from 17 February 2012. The undisputed fact is the instant case necessary for adjudication of the writ petition noted herein after. As per the STP scheme, in order to be eligible, an employee of the CISF is required to have completed 12 years of service from the date of appointment to a post without any promotion, financial benefit being made available to him, and he should also have successfully undertaken the promotion cadre course hereinafter referred to as PCC. The petitioner has stated that an employee is granted 3 chances for successful completion of promotional cadre course as per the applicable ACP scheme which has been placed before us. This is uncontroverted. The learned counsel for the petitioner submitted that the petitioner completed 12 years service on 17th February 2004 and was offered an opportunity to undergo PCC pursuant to an offer made only in December 2006. The petitioner could not undergo PCC in the said place due to medical unfitness, fracture in the right leg, and was asked to return to his unit of posting PCC as per advice of the doctor in the training center. It is also an admitted fact before us that the petitioner was granted financial upgradation by the respondent with effect from 17 February 2004. The record placed before us shows that the petitioner successfully qualified the promotional cadre course, and the result of the same was informed on 24th November 2008 by the respondent. It appears that prior year to the respondent have issued an order dated so whereby the ECB benefit granted to the petitioner with effect from 17 February 2004 was cancelled due to his failure in the promotional cadre course, which was held with effect from December 2006, which he has undertaken as his first chance. As a result, the respondent proceeded to recover the amount paid to the petitioner toward the financial upgradation from 17 February 2004. The petitioner representation to respondent were of no avail. The respondent, however, proceeded to re-grant the SCP application to the petitioner by order number so-and-so, dated so-and-so, which was made effective only from 12 February 2009. The petitioner was thus denied the benefit of the financial upgradation with effect from 17 February 2004 to 11 February 2009, which date he has granted the first financial upgradation. Learned counsel for the petitioner has committed that the respondent have done grave injustice to the petitioner in as much as the ACP upgradation could not have been withdrawn. It is further contended that the person become eligible for consideration of grant of ACP upon completion of the requisite number of years, which the petitioner has already completed on 17 February 2004. The manner in which the respondent worked the ACP scheme is that the effective date for consideration of the person for entitlement of the grant of financial application is the date on which he acquires the requisite number of years of service in a post without any promotional opportunities being made available to him. It is urged that the completion of the actual PCC would have no effect on the effective date of the grant of financial benefit in as much as all employees undergo the PCC only after having becoming eligible for grant of ACP scheme. It is urged that the same is apparent from the fact that the respondent granted the ACP application to the petitioner with effect from 17 February 2004 and he completed 12 years of service of continuous service in the rank of constable without any opportunity for promotion to the next post of head constable being made available to him till 17 February 2004. It is submitted that as per the scheme of the respondent, every employee is given free opportunity to complete PCC. As such, the inability to successfully complete the PCC in the first or second attempt would render the petitioner eligible for the third opportunity. So far as withdrawal of financial upgradation benefit, learned counsel for the respondent has placed reliance on paragraph number 4 of circular date so-and-so, which is to the effect that the allowance pertaining to the period from the date of upgradation of scale under the ACP scheme to the date of stoppage of such financial upgradation. Learned counsel for the petitioner has also drawn our attention to circular number so-and-so, wherein it pointed the respondent have themselves drawn a distinction with stoppage of the financial upgradation withdrawal not relevant, my lord. Paragraph 9 is relevant. In support of the contention, learned counsel for the petitioner has placed reliance on the pronouncement of this court order dated so-and-so, WPC number so-and-so, Har Gobind Singh versus so-and-so. In this case, the petitioner was seeking restoration of his second financial upgradation under the ACP scheme with effect from 3rd November 1999 and further grant of third financial upgradation with effect from 1st September 2008. It is noteworthy that The petitioner was granted the second upgradation under the SCP's conferred November 19, but the same was withdrawn without notice to the petitioner, resulting in the claim in the writ petition. The stand of the respondent has been noted in paragraph 5 and 6 of the judgment. The undisputed position the petitioner was granted the benefit of the second upgradation under the SCP scheme with effect from so and so, but the same was withdrawn without notice to the petitioner, and thus the claim of as per the counter affidavit filed on so and so, benefit was granted to the petitioner on 3/11/1999 in ignorance of the fact that the mandatory promotional course was not successfully undertaken by the petitioner, and when this was realized, petitioner was required to attend the promotional further course commencing on so and so, for which he expressed his unwillingness to attend the course on so and so. This very contention is urged before us, just as the present case in hand. The petitioner Hargobind Singh also did not get the opportunity to undergo PCC course on the date he became eligible for the grant of further financial upgradation, which was withdrawn. On this aspect, in Hargobind case, this court has ruled on the respondent contention urged before us as well. Commented on the responsibility of the department to detail the person for undertaking the promotional course. In this regard, observation made in para 8 to 12 of the judgment are relied upon. Learned counsel for the respondent urged that the issue at hand is squarely covered against the petitioner as per the judgment so and so disposing so and so. A perusal of the judgment of Bhagan Singh case Supra would reveal that the petitioner therein was working as hard possible and was denied the second upgradation under the SCP scheme on account of the fact that he consciously refused to undergo the mandatory promotional course, which would have made him eligible to be promoted as an assistant sub-inspector, and in writing had given that he forgoes the right to be promoted. The division bench at paragraph so and so notice so and so. Grant of higher pay scale under the SCP scheme shall be conditional to the effect that an employee while accepting the state benefit shall be deemed to have given his unqualified acceptance for regular promotion on concurrence of vacancies subsequently. In regular promotion subsequently, he shall be substituted, is not relevant, Lord. We can come to paragraph 11, Lord. In this case, whatever decided up, Lord, is that if I qualify it within 3 chances, that is in paragraph 7, Lord, then I would be entitled from the date of my completion of 12 years.
12 years.
Lord. That is there. So I qualify, other categorization I was having, PCC I qualified in 2006, Lord. In such circumstances, Lord, I am entitled for ACP benefit from 2000 onward. This is the first concept. Yeah.
You completed 12 years in 2000.
No, I was 83, my lord, so I completed in 95, my lord. ACP came into existence first time in 1999. In 2000, I completed without that. The 12, when I 12 years.
After coming into the particular scheme in force, the completion of 12 years was into 2000.
Sir.
Otherwise, this before the scheme had come, you had practically completed, and thereafter you had qualified in the PCC factor in 2006.
Sir.
You are contending that at least from 2000,
Sir.
when the effect was given, you should be given the benefit.
Because
now, what is their stand?
They have not taken any stand on that. Now,
No, the rejection. How is
Look,
the defending the
they
rejection?
say that in 2006, my lord, so I qualify PCC, my lord, but in 2006, I don't have the benchmark, my lord. That I, in 5 years, ACS, my lord, does not count to 15, total numbers of 50. That is
No,
their-
that may be relevant for consideration for the next.
Lordship.
Initially, there were 2, then it was
Yes.
increased to 3, 10, 20, 30, initially
Yes.
12
MSCP.
and 24. MSCP had come, but you are sticking your claim for the first one. First one, and your qualification, the PCC, should be related to the first one, not for the second one.
Not for the
And
first one, the consequent benefit I will get, my lord. Now, so far as ACRs are concerned, my lord, they have taken a stand, my lord, in the affidavit of opposition.
So far as your consideration in 2000 is concerned, was the ACR for that period okay?
Yes.
You qualified in the ACR factor.
I qualified, my lord.
The PCC was left out, which you qualified in 2006.
Lord.
Yes, Mr. Bora.
That's it. One more paragraph, my lordship permits, my lord, of their affidavit in opposition, my lord. Paragraph 12, my lord, page 16, internal page is there, of their affidavit in opposition, sir.
Page
16, internal page of their paragraph 12, my lord. Pagination maybe
Para 12, yes.
Paragraph. That the amendment made by the petitioner, paragraph 9 of the writ petition is false, based and figment of his imagination. In fact, adverse remark in STR, if any, is communicated to the concerned person as per rule. Before, but the grading of the petitioner were not adverse in nature. In accordance with Rule 202 of Supplementary Rule 1970, the petitioner has regularly checked his service book and verified the entries made, therein certifying that they have found it correct. We have never been furnished with a copy of the STR. So that way also the case goes.
But it was not, there was no adverse remarks.
Even if there is no adverse remark, there is settled law, my lord, of
No,
the.
Devdutt, you did not go to Devdutt.
Because I was given.
No, no,
good,
why,
my lord.
why do you need, why, how is it relevant?
My lord, I was given good, my lord. In this case, what happened, my lord, in case of Sukhdev Singh, my lord. Good
Sukhdev
was
Singh
done.
is based on Devdutt only.
Lord. Correct.
I think
So,
Sukhdev
but-
Singh is also by
Yes.
Justice
Only,
Kaju.
only one paragraph, my lord, that is.
No, no, how are you prejudiced?
Not prejudiced, but only to my lord, second stand that I have not, benchmark was not made, my lord. For that only I have seen the thought, my lord. Otherwise, 2000, if I am granted, subsequent everything.
No,
would-
they are harping upon some penalty imposed upon you.
No, my lord, the penalty that were imposed upon me, my lord, if you lordship sees that also, my lord, that is, my lord, at page annexed as, my lord, page.
But even otherwise, the
Even
penalties,
otherwise, I meant.
penalties may be effective
No,
for
that
this
will not be a
second
penalty.
upgradation. But the first upgradation, there was no penalty. Was there any penalty for the first
There
upgradation?
was, my lord, but that was not there. For penalty, the rule is, my lord, that 3 marks should be deducted. ACR marks could be like that, my lord. Excellent, if I get excellent, I will be granted 16 marks. Very good, 14, good, 12, average 9, below average 0. That was the marking system in there.
And if there is a penalty,
That 3 marks ought to be deducted. That was there. But if your lordship says, my lord, paragraph P annexed F, my lord, the penalty imposed in 2006, my lord,
page,
page 32, internal page 32, my lord, of the affidavit in opposition.
yes.
Number 7, column number 7, avoid undergo PCC at RTCA. 2-day fine by final order number so and so, 6/5/2006. Lordship has it, my lord. Column number 7, my lord.
Yes.
Avoid undergo PCC at RTCA. Now, if your lordship takes up the Central Industrial Security
No,
Pool,
that is only one of the penalties.
there is other penalties where 2002-4, if all the penalties are calculated, my lord, there are deduction of 9 marks, then I may qualify, I may not qualify. There is again a dispute to that, lord. But if this goes, my lord, then 6 marks to be deducted, I am getting 59 marks, my lord.
No, why are you picking up only 7? That is avoid, undergo.
My lord, because that is not a penalty in terms of the rule. Yes, a rule, that is not a penalty.
Okay, that penalty may go. What about the others?
Even if the other stands, my lord, then also I am entitled, my lord. I would qualify, I would cross the benchmark. But that matter will not come if your lordship is satisfied with the first argument, my lord, then it will go, my lord.
What is OSL?
Overstaying leave, my lord.
Overstay leave 31 days, sleeping on shift duty. Overstay leave.
It is.
Not
10 minor penalties were imposed on me, my lord. In my 35 years of career, approximately more than 34 years of service.
not ready for periodic changing and consumed alcohol. Sleeping with arms while on duty.
If your lordship takes up rule 34, my lord, for a moment, yes, if not, that is not.
Rules कौन लगेगा? ऐसे
Rule 34.
Yes.
Major penalties, minor penalties, my lord. After there is an explanation, my lord.
Yes.
The following shall not amount to a penalty within the meaning of this rule, namely, withholding of increment of an enrolled member for failure to pass a departmental examination in accordance with it. So PCC would not come under, my lord, failure to avoid PCC will not come under a penalty. That is my.
But that only one will go, 7 might go. This 7 might go. What about the
Seven, if 7 goes, my lord, if you lord, please calculate, my lord, the number which is in the previous page 31, my lord, next to E, my lord. From 2005 onward, if you lord, consider average 9 mark. Average is 9 mark, 2005. Good 12, lots of 21, it comes 21. Again, very good is 14, 35. Good is again 35 plus 12, 47. And again, good, my lord, 47 plus 2, 59, my lord. And the punishment that was imposed, my lord, are 2 only from 2001 to 2, my lord. 3 numbers would be deducted, my lord. 9 numbers I will come within 50, my lord. Then also I qualify the benchmark, my lord. Punishment 2001, 2, and Isha is coming for. If consider the first argument, my lord, this becomes irrelevant, my lord. Because I consider a PC in terms of the judgment I qualify, my lord.
Yes, Mr. Bora.
Wait, Lordship खाली peruse है, however, it's made in paragraph 5 and paragraph 6 of my proposal.
5 and 6.
5 and 6. This will, everything will be clear.
Page
Page 9. Because may I read it? Paragraph 5. The evidence made by the petitioner at paragraph number 2 of the decision is vague, baseless, and apart. It is submitted that the petitioner was appointed as a constable on 1/183, but his date of supervision is 38 August 2018, not 1/7/2018. As he mentioned, though there is a provision for financial upgradation under STP scheme on completion of 12 years, 24 years of regular service in the grade in which he was appointed as a direct recruit, the petitioner has not fulfilled the eligibility criteria for the provisions that he did not attend qualified promotional career course, did not secure benchmark for which the screening committee has found him not yet fit for the same. The petitioner was well aware about this fact. In this regard, reference may be taken that he verified his service documents and signed a certificate to this effect. He says to have verified the entire entries made in the service document. I am sorry, sir, I am not physically well, but so I have come to be so any error.
No problem. Now, if you are not well, we can have it some other day. Why didn't you tell us?
Please to paragraph 2.
Now, if you are okay, if you think that you can do it, otherwise we can have it some other day, no problem.
My Lion Peters second promotion.
I have not helped, lord. Lord, you can keep the matter part-heard, lord.
No, this bench is continuing. I'll not keep it as part-heard, but we can accommodate him, Mr. Bora, any other day.
Too difficult. Yes, lord.
And when can we do? Next Tuesday?
2 weeks.
If it is next Tuesday, then there is a chance that this bench is continuing. So
Lord, can keep it part-heard, lord. Lord, you already heard
part-heard
the
we
matter,
not,
lord.
we do not keep part.
Leave it to lord discussion, lord. But lord, you heard
Next
the-
Tuesday, Mr. Bora, are you there?
Lordship.
After a week, next Tuesday?
Lord.
Next Tuesday we'll have. no?
Next.
You could have indicated, otherwise you'd not have given so much time.
Lord.
Yeah,
Heard three A Lal, learned counsel for the petitioner. Para. On the request of Sri DC Bora, learned CDC. Matter is adjourned to be listed on Tuesday.
further consideration, my lord.
We are not saying anything. This is continuing. Tuesday we'll have it, don't worry.
I move. Obliged, Your Worship.
এটা যে আছিলে কিবা ৰখিব পৰাটো পিছত মাতিম বুলি আহিছিল নাহিলে আহিছিল ন এছচি বিশ্বাসৰ আহিছিল Yes, what is this?
So the challenge to a order of termination from service.
Who's from the other
by
side?
the government of here. Was terminated from the police.
Health department. 16 is it, Mr. Magundar?
I'm on the wrong case then for the time.
No,
It was
16 is
WPC 9445 of 90.
9445. It's your case.
Yes. Health is wrongly stated. Because health is a party, they had given a police report, but the termination orders have come from the
Home Department.
Commandant Police.
Home Department. You are there? Are you ready for the matter, Mr. Dhar?
No, my lord, some, because of that, this health department thing, my lord, the file hasn't come. No,
Health issues are there.
health issues are there, my lord. That
Health is important.
health is important.
Because only the standing medical.
But
board had
home is
given a-
more important.
Home is important.
Health. Mr. Borpujari, health? No, wealth.
He is wealth, my lord.
Wealth.
He is Mr. Kubir.
He is wealth. He is not concerned with health. Who is concerned with health? Anybody in the court concerned with health? Mr. Chaudhary is concerned with health.
He Gogoi.
Okay, we'll direct list showing his name.
Otherwise, not the health department, otherwise does not have any.
No,
Except one-
Mr. Dhara, if you are otherwise, you can, we can have it day after tomorrow if it's your concern. Day after tomorrow.
Yeah.
Old matter, 19 matter. Okay. Now, GA Assam is otherwise shown in the list.
Yes.
Maybe there's some confusion because of
Confusion,
that.
ma'am.
Okay. On the request of Heard Sri R. Mazumdar Learned Counsel, no, those three R. Mazumdar Learned Counsel for the petitioner is present. Comma, request has been made for adjournment by Sri R. Dhar, the Learned State Council, full stop. Para, list on when?
My lord,
Next Tuesday,
24th minute,
23rd,
23rd, 23rd.
23rd, next Tuesday. Okay.
Okay.
Yes, Ms. Bora, your matter is ready or not? Ready to.
Wait, please, your lordship. This was the selection and appointment filed by the petitioner. Was the list which are issued by the respondent.
Just a minute, just a minute, just a minute. Home Guard
Yes, sir.
in the year 2014.
14.
Yes, what had happened? There was a selection process
Yes, selection process. but
in the year 2014
Yes.
for Home Guard. Okay, then what happened? You participated.
Yes, sir.
How many of you?
The
How many?
17.
Participated.
Sir.
This was in which district?
District Nagaon and Nalbari.
It was for the entire state.
Yes.
Okay, then
Then The selection was conducted on 21st 10 2014 and 22nd
21, 10, 14. And
and 22nd 10 2014.
2 days.
2 days.
Selection.
That is for the district of Nagaon.
Oh,
And in Nalbari, it was conducted on 17 10 14.
for nobody.
For Nal-
Okay.
Okay. In these 2 days, the petitioners appeared for the selection test.
Few of you belong to Nagaon and few of you to Nalbari. Okay. Then what happened?
Then the committee produced the selection list in a very hurried manner. It was listed on 31st 10 2014 and another list was put forward on 3/11 2014. That is for the Nalbari district. That is, and that too in an odd period of the evening
31, 10, 2014 is for Nagaon.
for Nagaon.
And
And for Nalbari district,
311 is for Nalbari.
for Nalbari,
Okay.
it's para 8.
Okay. Then
So they and 156 candidates were selected. That too in a hurried manner without taking proper time for the
why? What proper time? These elections were held on 21st. Select list published on 31st. Where is the hurry? If there is delay, you come to the court, select list not published. If they do it on time, you are still aggrieved.
No, oral
Why have
test
you
was-
done it on time?
The oral test was also not conducted.
That is your contention.
Yes.
166 candidates selected. Say 166 in which district? Nagaon district. Nagaon, Nalbari,
Nalbari 200,
200,
226.
Article 226.
Yes.
Nalbari, okay, then what happened? What are your contention? No oral.
The contentions that in the selection list, the persons who were selected, they have not appeared for the
Interview.
interview. The selection test, they have not given any kind.
Did they appear in the selection process?
No.
They did not even appear in the selection process.
Even, and
Who
they,
of those?
one name is mentioned in para number 10, that is Sarif Ahmed, that is serial number 52. And serial number 121, Abdul Hamid from Nagaon district.
Made parties.
For the 15.
Did you appear?
Yes, sir.
Appear till the last day. Or interview, did you appear?
Oral interview was not conducted, but till medical test and fitness test, I have appeared.
You appeared. Where have you, which paragraph have you made statement that some candidates have not appeared? Let us see.
Paragraph number 10, Lord.
10.
10.
Let us see how have you, what have you stated there. Yes. Please read.
Many persons who did not appear in the selection process were selected.
Sarif Ahmed, 22, and Abdul Hamid, 121 from Nagaon district. What is your source?
That is, I don't have the source, that is the contention.
Very vague. These persons have not been made parties otherwise also.
That is
And even recasting of select list of 2014. Was there any interim order passed? No.
No.
and the advertisement. The request for the advertisement. The page number
1-8.
1A. Next so
Yes.
class line enrollment. The audit temporary for selection of homeguards for just for 42 days rural homeguard specific. That post shot. So the
Those who have duty filled up enrollment form.
enrollment is
Enrollment is period employees. This will not have any substantive effect also, madam.
It's already dead.
42 days only. Okay. Heard Miss A. Bora, learned counsel for the petitioners. Full stop. Also heard Sri D. Bora, learned state counsel for appearing on behalf of all the respondents. Full stop. Para. The petitioners, who are 17 in numbers, have approached this court by filing this petition. Please have your seat. Under Article 226 of the Constitution of India, making the following prayer, page 14. As per the facts projected, comma, a recruitment drive was taken in the year 2014 for enrollment of 600 Home Guards volunteers. For and for imparting 42 days of Home Guards rural basic training. The petitioners who had participated in the aforesaid selection are confining in the districts of Nagaon and Nalbari. Full stop. It is contended that while for the district of Nagaon, the selection was held on 21/10/2014 and 22/10/2014, comma, for the district of Nalbari, the selection was held on 17/10/2014. Full stop. It is contended that the select list was published hurriedly and in a harsh manner. Full stop. For the district of Nagaon, such select list was published on 31/10/2014, and for the district of Nalbari, it was published on 3/11/2014. Full stop. Nagaon to selecting 166 numbers of candidates are Nalbari, selecting 226 numbers of candidates. Full stop. Para. Ms. Bora, the learned counsel, has submitted that many of the selected candidates did not even participate in the selection process. Full stop. In this connection, comma, the learned counsel has drawn the attention of this court to the averments made in paragraph 10 of the writ petition, which reads as follows. Para. The learned counsel submits that under the aforesaid context, the relief has been prayed for recasting the select list. Full stop. Para. Sri Bora, D. Bora, the learned state counsel, on the other hand, has submitted that the writ petition itself is not maintainable, inasmuch as none of the selected candidates have been made parties, whereas the prayer is for recasting the select list. Full stop. It is submitted by the State Council that the allegations are absolutely vague, and even though two persons have been named in paragraph 10, comma, they have not been made party respondents in these proceedings. Full stop. He submits that even on merits, the writ petition is not even liable to be entertained, inasmuch as the advertisement itself had clearly mentioned that the enrollment was only for 42 days of training, which is long over. Full stop. Para. The rival submissions have been considered. Full stop. Para. It appears from the recruitment notice that the recruitment was for 1,600 Home Guards volunteers to undergo 42 days rural Home Guards basic training only. Full stop. Apart from the fact that the allegations are vague and not substantiated by any materials on record, comma, the selected candidates have not been made party respondents. Full stop. Even the two candidates who have been named in paragraph 10 with a specific allegation that they did not participate in the selection have not been made parties. Full stop. Any attempt to consider the cases of the petitioners without giving the selected candidates an opportunity of hearing would be against the principles of law. Full stop. In any case, comma, the recruitment being for undergoing training for 42 days, comma, the no effective relief can otherwise be granted to the petitioners. Full stop. Writ petition accordingly stands dismissed. Mr. Chaudhary, which matter is yours? 2 o'clock, what matter?
It's a dismissal concept. I had a talk with him. The
What
thing is
post,
that
what post?
the concept honor
After DP?
after TP and appeal was also.
What are your main grounds
My procedure is irregular. Primarily.
in the inquiry?
Yes. My difficulty is that today the file is not available with me. I'm using the second file.
We need to have the record also. Are you making some
the
allegations on the inquiry you have
The
thrown?
records are there, Lordship, but I've not gone to the record. But this file I just got paid.
You take the court file. Or we can hand it day after tomorrow.
That's all right, but he has some difficulty, but
Day after
somehow it
tomorrow.
will be-
Tomorrow?
Tomorrow, yes.
Tomorrow we can, you have a look at the file. Matters of when was the dismissal? Dismissal or removal?
My lord, dismissal is of 2020. Dismissal was in 2017, my lord. Appeal rejected 2020.
If you can go through the file in this, during the recess, we can have it at 2 o'clock. Because we are rising early today, we can finish it the matter 1 hour. Let's try today, have the file. Have the file, have a look at the, we don't need so much, or you have the record with you.
No, he said
Pleadings
he-
will not make any difference. This is a DP matter.
I have no difficulty tomorrow. Day after,
Kadiba Kiman matter. Second matter, second parim. Tomorrow. Okay. Okay, tomorrow we'll have it. On the request made, Sri M.K. Chaudhary, Senior Counsel for the petitioner. On the request by Sri C.S. Hazarika, London State Council, list tomorrow.
apply.
Tomorrow, but is it for hearing today?
Yes, sir.
Oh, Kali to hearing to now. It'll be listed for hearing, but if we have time, we'll take it. Today, if you can, not to cause any difficulty to you, but if you think you can manage, otherwise tomorrow. Let us try tomorrow then.
Thank you.
এইটো এই যে লালে কেছ কৰিছিলে যে তাত থাকিলে
Please, Your Lordship.
Yes, yes.
Lordship, this petition is filed by the petitioner for regarding the area salary and allowances for his first financial upgradation, Lordship.
Goes for the other state government. Oh, CCC.
SNSD.
Hmm? The central government. The state government or central government?
Central government.
Mr. Bora, who is there for CCC? Oh. 1 and 2. Who is 1 and 2? Against whom? Central University.
Sorry?
Against Silchar, which, who is 1 and 2? Okay, Tezpur mental health.
SGPA.
Okay. Is it?
No, he does not appear in this case, sir.
Then who would appear? What is the matter?
The matter relates to the
Upgradation.
upgradation, Lordship.
Try to get hold of some CCC. It will not be possible in their absence. And their names have also not been reflected properly.
Respondent number 1 and 2 has been selected as the SP Chaudhary.
Is he appearing?
On the last date, he did not appear, but in the previous date, I have to check.
Last date, unfortunately, you also did not appear. 36/20/24, none appears for the petitioner.
I was not there before.
I think SP Chaudhary would be appearing. You just tell him, okay, we are adjourning this matter. We'll have it next Monday. Okay. Do Miss A. Bora, learned counsel for the petitioner, is present? There is none to represent the respondents. Full stop para. In the interest of justice, matter is adjourned to be listed on Monday next date. Please inform Mr. SP Chaudhary.
Item 19.
May it please the court. Lordship, matter relates to Lordship, pension, area salary and pensionary benefits. You may propose order date T4/24.
Lordship, I pay the.
Okay, yeah, yes, we can go ahead with this or what? Has it been settled?
The pension proposal has been sent to the AGO as per the instruction. So
Sent to
now
the
AG,
AG office, okay. Yes, Mr. Bhattacharya, anything?
I'll have to get that. I have just talked to know about.
When was it? Oh, this was recently, I think it should be sorted out. Okay, we'll record this and
otherwise he is
we'll grant some time
Yes.
and we'll have this after around one month. Okay.
otherwise he is getting the provisional pension.
No.
Because
Provisional,
as per the,
I have not
case
received
that-
provisional pension. I have received
an amount of rupees around 2 lakhs 40,000 as area salary in 3 installments, Lord.
You take instructions from your client.
So,
I think as per this written instructions, you have received your provisional pension, provisional DCRG and leave salary. Maybe the instructions which you have got is prior to 11th of July.
yes,
Maybe.
prior to 11th of July. This is on June, last week of June, Lord.
Okay. So,
If
I
three-
just got something on, I sent those documents. Said that we go to this as a duplicate. They have artisted to expire of habit. Now they will need the consent treasury of.
okay.
Treasury party could.
SN Krishnatra,
yes, sir.
Sri SN Krishnatra, learned counsel for the petitioner. Full stop. The matter relates to pension and other post-retirement benefits. Full stop. Para. Sri D. Bora, learned state counsel, has, however, placed before this court written instructions dated 11 July 2024, along with connected documents, as per which the pension proposal has been forwarded to the AG Assam on 26/4/2024. Full stop. It has also been stated that the petitioner has received provisional pension, provisional DCRG, and leave salary. Full stop. Sri D. Bhattacharya, learned standing counsel AG, has submitted that the proposal has been received by the AG office and is on process. Full stop. Para. In view of the aforesaid development, this court is of the opinion that interest of justice would require some time to be given to the authorities to finalize the same. Para. Accordingly, matter is adjourned to be listed after 6 weeks.
Let me pick.
6 weeks. List on
Part of the
28th of August. 28.
obliged.
You take back these papers, Mr. Bora.
Yes.
Obliged.
Uh,
Yeah.
What is this?
My according the defense of the respondent authority, Lordship, that my father was discharged from his services, Lordship, due to unauthorized absence, Lord. That is
Okay.
categorically mentioned, Lord. In this case, Lord, I am apart from challenging the discharge certificate, Lordship, which is stated issued by the respondent authority, Lordship, now claiming from only for pensionary benefit of my deceased father, Lord. When Lordship he was died, I was in minor Lordship having age of 13 years. Only for claiming pensionary benefit.
Your
from
father
other
was
benefits.
working as what?
Lordship,
He was working as what?
Lordship, my father was working as a constable, Lordship, in railway department initially, Lordship, and thereafter he was transferred to the Shivsagar, Lordship, in the same post, Lordship, as a constable, Lordship, and prior his discharge, Lordship, he was rendering more than 26 years. So, Lordship, the prior he discharged, Lordship, he is entitled to get entire pensionary benefit. Even, Lordship, the discharge is not a punishment, Lordship. Nowhere mention that, Lordship, that discharge is the punishment. Discharge is applicable in case of professional officer, your Lordship, basically, Lord. But even, Lordship, the government employee may be discharged, Lordship, when the post have been abolished, Lordship.
Now you want the pension.
Yes, only for pensionary benefit. I
Your
have
father has passed away.
Yes, Lord.
When?
In the year of 2011, Lordship.
2011.
Yes, Lord. And he was discharged on 2009 year. So, Lordship, as per Police Act, Lordship, that is clearly mentioned that, Lord, discharge are not punishment, Lordship, and that also get all pensionary benefits, Lord. At Police Rule 104, Lord, Part 3, Lord, Assam Police Men. That is also categorically mentioned.
That is your case.
No.
That is your case.
Yes, sir, only that is my.
You want the pensionary benefit.
Yes.
Your mother is there or not?
No, Lordship. She also died, Lordship. Prior date of my father, Lordship,
Father.
he was died.
Yes, Mr. Bora. What is he saying?
Your Lordship, there was this affidavit, page number 42, paragraph number 6.
Yes.
Case of the petitioner's father was basically a habitual offender. He was habitually absenting himself from office. It is not the case that it is a first time offense and that he had remained absent without any authorization. He actually remained absent on many occasions. And ultimately, show-cause notices were sent one after another. And finally, it was served in the year 2008. And it was received by the father also. And I have the record also. And it has been received by the father of the petitioner. Thereafter, even then also TP proceedings were drawn up in the show-cause notice. He was clearly intimated that the TP proceedings will be drawn up against you if you do not actually appear. But even then he decided not to appear and ultimately he was discharged from service. And in the year 2009, 6/9/2009. And prior to that also, the petitioner's father, he was suffering from TB and he had actually taken leave on other early occasions. He was on TB leave for 540 days prior to in the year 2002 to 2004. And thereafter, he even after receipt of that particular show-cause notice dated 12/12/2008, which was received by him on 15/12/2008, he did not actually appear. And ultimately, the TP proceedings were drawn ex parte and he was discharged from service. And as per the affidavit filed by the respondents, they have stated that since the petitioner was discharged from service for his prolonged unauthorized absence from duty, the period of his unauthorized absence was treated as leave without pay by the order dated 9/6/2009. And as such, the petitioner is not entitled to get any pensionary benefit.
That is the admitted fact, Lord. Therefore, I am not challenging the discharge certificate, Lord. Apart from the discharge, Lordship, I am claiming only pensionary benefit, which I am legally entitled to get to your Lordship, as per the Police Act, Lordship. Even Lordship, Assam Service Pension Rule 1969, Lordship. Rule 69, Lordship. That is clearly mentioned that if an officer is selected for discharge, Lordship, owing to the abolition of a permanent post, he shall, unless he is appointed to another post, the condition of which are deemed by the authority competent to discharge him to be at least equal to those of his own, have the option of taking any compensation, pension, or gratuity to which he may be entitled for service he has already rendered, or of accepting another appointment of transfer or transfer to another establishment even on a lower pay if offered, and continuing to count his previous service for pension. So, Lordship, on basis of this
Now,
Rule
how
69,
do you withhold the pension, Mr. Bora? If you come to the 1964 rules, there is no penalty of discharge. It is not a penalty. There might have been a DP, and DP found him guilty, but you did not penalize him. So if you have not penalized him, but you have discontinued his service by using the expression discharge, you are discharged. That doesn't mean that he has been penalized. And by that, can you deprive him of the pension?
Sorry, Your Lordship, the last point.
Now, can you deprive of a government servant from his pension? And pension, it would only be for the period, from, till the time of his expiry. Will not get anything more than that. From 2009 to 2011. After that, he passes away. So son gets nothing.
I agree, your
There is
lordship.
no concept of family pension for a son.
Lordship, at the time of lordship, death of my father, lordship, I was minor. So lordship claiming only the during the period, lordship, till 13 years to attaining 18 years, lord. On basis of that such claim, I am right. Apart from this, lordship, and the retirement benefit, lordship, I have claiming. Only because of that, I
What
am
is your
claiming
age?
the
What,
same,
what is your age?
lordship. My age was having 13 years, lordship, at the time of
No,
death
now,
of my father, lord.
presently.
Yes, presently, lordship. My date of birth is 1998, lordship, and presently, lordship, 26 years. So, lordship, counting only from the
And
age of
family pension is available to whom?
lordship, family pension is available for the first class legal heir, lordship. It may be the wife of the deceased, either the children, lordship. But having more than 18 years, the child cannot claim the pensionary benefit,
Let
lordship.
us see.
Because
Family-
of that, lordship, I am claiming family pensionary benefit, lordship. At the time of death of my husband, while I was in minor, at the time of death of my father, lordship, I was having 18 years, 13 years, lordship. Since 13 years to 18 years, period of 5 years, lordship, I am claiming the pensionary benefit, lordship. Apart from the pensionary benefit, lordship, other TCRT and other retirement benefit, I am entitled to get benefit, lordship. As per the police act, lordship, that is discharge, that is clearly mentioned that lordship rule 104, lordship, discharge, lordship. If any government employee has been discharged from their services, lordship, he may be entitled to get all the benefit, lordship. Retirement benefit, as because discharge is not punishment, lordship. And nowhere mentioned, lordship, in the some disciplinary rule, lordship, section 7, lordship. Rule 7, lordship, that is clearly mentioned that the penalty, but nowhere mentioned that the discharge is the penalty. Discharge is applicable under those person, lordship, who is working on basis of the probationary basis, lord. My father's service was is the permanent service, lord. So he may not be discharged, lord. And even, lordship, he may be discharged. And what circumstances, lordship, if any post have been abolished, lord, and abolished from the post, lordship, he may be discharged, lord. Otherwise, lordship, it may not be, lord. And lordship, may I read, lordship, rule 104, lordship.
Please read.
Yes. Discharge. All men who were to be discharged will be brought into headquarters. Their uniform will be taken from them and dealt with in accordance with Rule 330. Their appointment certificate will be withdrawn. Their account will be settled and their dues paid to them. Their pension and gratuity rule will be prepared. Or when this is not possible, all necessary information for the preparation will be obtained, and then, not till then, are they to be discharged. Should be men fail to obey the order to join the reserve prior to discharge, he should be treated as absent without leave. The date on which an inspector, sergeant, major, and sergeant vacate his appointment on the retirement or discharge should be promptly reported to the inspector general. And 105 discharge certificate. If any government employee has been discharged, the discharge certificate has been must issued by the authority. In this case, lordship, I am not challenging the discharge, lordship. I admitted that my father was discharged from these services. On basis of the date, I am claiming the retirement under benefit, lordship. And the period of pension, lordship, till 13 years to attaining 18 years, lordship. Only for the period of 5 years, lord. After 18 years, I am not claiming my pension, family pension, lord. I am not entitled to it. As per the Assam Service Manual rule, lordship, the family will entitled to get the family pension, lordship. It may be the first legal heir. So, lordship, wife is entitled. My mother is not alive as of now, lordship. But at the time of I was minor, claiming such benefit till 13 to 18 years. So, counting this period, and granted such benefit, which I am entitled to get, and other retirement benefit and DCRP, death come retirement benefit.
Yes, Mr. Bora.
The Lordship, I admit that discharge is not that a scheduled punishment as per the Assam Disciplinary Service Rules, but the Lordship, he was actually unauthorizedly absent, and the stand taken by the department as such, since he was discharged from service, he is not entitled to pension benefit.
Now, under what law?
At post
Your action has to be justified by law.
Law.
Allegations may appear to have been proved, but you did not impose any penalty.
For your kind attention, Lordship, I have a judgment of our own. I will go on.
Mr. Borpita, you are appearing for
fine.
no, those aspect will come, but his entitlement. See, there was a DP, we found that there was a DP, but DP did not culminate in an order of penalty. It ended with an order of discharge, which is not one of the prescribed penalties. And he passed away after 2 years. So 2009 to 2011, pension would be admissible to him, pension and other post-retirement. And what the petitioner is claiming, father passed away. He was at the time 13 years old. Mother predeceased. He is also claiming family pension till the age, of course, that has to be till the age he attains majority. Yeah, till 90, till he attains 18 years of age. So that period, and I don't find that the denial of these benefits are supported by any law. But that will not be enough. In fact, the affidavit, we have read the affidavit, there are allegations which are not very light. He was unauthorizedly absent. He cited some illness, but still then he overstayed leave. And there was a fit case for either to remove him from service or whatever, which was not done.
So, whether the spectrum of discharge might not be considered as a penalty.
You cannot. You cannot. Penalties are prescribed in 7. You have to give one of the prescribed penalties. You cannot give any other penalty. It will not be constituted as a penalty.
If it is not considered a penalty, but then again, entitlement might not.
You cannot, yes, you have to give him. See paragraph 13, very clear of your affidavit.
Yes, their affidavit.
There with regard to the statement so deponent begs his father, the petition was discharged.
From service, and hence he was not entitled to get pensioner benefit. Now,
Both are not matching.
Then again, he petitioner being the dominant statement have satisfied the right.
No, that will clarify. That to get this, he will have to give whatever formalities are there, the next of kin, his age,
Duty bound.
his age, because he will not get anything after he attains majority.
For that period, he will have to give the proper testimonials before the authority.
We'll clarify those. In fact, you should have given the next of kin in this writ petition itself. We are deciding on principle, but your entitlement,
Yes.
it has to be based on facts. Third, Sri M. Chaikya, learned counsel for the petitioner. Also heard Sri D. Bora, learned state counsel, appearing on behalf of the respondent numbers
1, 3, 4, and 5.
1, 3, 4, and 5, whereas as well as Sri R. Borpujari, Learned Standing Counsel, Finance Department, for the respondent number 2. Full stop para. Considering, have your seat, please. Considering the nature of the grievances and also the fact that affidavit in opposition has been filed, comma, this petition is taken up for. Oh, this is for hearing, I think. লিখেন দিব নালাগে it last line to নালাগে consider নালাগে লিখব the projected facts in the petition is that the father of the petitioner, Horen Fukon, was working as a constable, AB constable, with the Assam police at Sibsagar. Full stop. Though a departmental proceeding was drawn against him, comma, the same did not culminate in any order of penalty. Full stop. However, comma, the father of the petitioner was discharged from his service in the year 2009. Full stop. The father of the petitioner had thereafter expired on 2011. Full stop. The grievance of the petitioner is that no pension or any post-retirement benefit was granted to the father during his lifetime after discharge, and no pension and no family pension has been granted to the petitioner till the age he had attained till the age of attaining majority. Full stop. Para. Sri Saikya, the Learned Counsel, has submitted that discharge as such is not a prescribed penalty under the Assam Discipline and Appeal Service Regulation 1964. Full stop. Under Rule 104 of the Police Manual 3, discharge has been stated, which is not a penalty and which will not preclude a government servant from the pensionary benefits. Full stop. The Learned Counsel clarifies that the aspect of discharge as such is not the subject matter of challenge, and the petitioner is only concerned with the post-discharge benefits, namely pension and subsequently the family pension, till the petitioner had attained the age of majority. Full stop. The Learned Counsel has clarified that the petitioner was aged about 13 years when his father had passed away, and his year of birth is 1998. Full stop. Para. Sri D. Bora, the Learned State Counsel, on the other hand, by referring to the affidavit in opposition filed on 5/2/2024, has submitted that a disciplinary proceeding was initiated against the father of the petitioner for unauthorized absence, vide letter dated 2009 and the proceeding was registered as 9 of 2009. Full stop. It is by referring to the averments made in paragraph 6, comma, the learned state council has submitted. Learned State Council has submitted that based on the findings of the inquiry officer, comma, the father of the petitioner was discharged from service on 6/9/2009. Full stop. The stand of the respondent, which appears from the affidavit, is that owing to such discharge, comma, the government servant was not entitled to any pensionary benefit. Full stop. Para. 3. Borpujari, the learned Standing Council Finance Department, has submitted that the petitioner has not annexed any documents like next of kin and other documents to stake his claim. Full stop. He also submits that though the expression discharge has been used, comma, the same has been imposed after completion of a departmental proceeding, and therefore the stand of the department may not be found fault with. Full stop. Para. The rival submissions have been duly considered. Para. The Assam Services within bracket Discipline and Appeal Rules 1964 lays down the nature of penalties under Rule 7. Full stop. Discharge as such is not one of the prescribed penalties, either minor or major. Full stop. On the other hand, comma, Rule 104 of the Police Manual 3, Roman 3, which is in connection with discharge, would make it clear that after such discharge, comma, the government servant would still be entitled for pensionary benefit. Full stop. Para. Para na, 6. What propelled the disciplinary authority to impose to discharge the government employee after the disciplinary proceeding is not known, is not revealed from the records. Full stop. However, going by the materials appearing from the records, including the affidavit in opposition, comma, there is no manner of doubt that the disciplinary authority, comma, in its wisdom, had discharged the government employee after the disciplinary proceeding. Full stop. Para. As indicated above, comma, the rules of 1964 do not envisage discharge as a penalty. Full stop. That being so, comma, it will not be proper or justified to withhold the pensionary benefits and other post-retirement benefits to the government servant or his family members when claiming family pension. Full stop. Para. Under the aforesaid facts and circumstances and the discussions made, comma, this court is of the opinion that the pensionary benefit from the date of discharge that is 15, that is 6/9/2009 till the date of death of the father of the petitioner, comma, the authorities, the respondent authorities are required to pay the pensionary benefits and other post-retirement benefits to the father of the petitioner, full stop. Additionally, since the petitioner was a minor at the time of the death of the father and claims to be the sole legal heir, comma, he would be entitled to family pension till the age of attaining majority, full stop. The petitioner is accordingly, para, at this stage, comma, the requirement of the necessary documents which were highlighted by the learned counsel for the respondents is also considered, full stop. Para. Accordingly, comma, the petitioner is directed to furnish all the relevant documents, including documents pertaining to date of birth, pertaining to his date of birth and the next of kin certificate, along with an application, along with a forwarding letter to the respondent authorities, accompanied by a copy of the present order, full stop. On furnishing the same, comma, the respondent authorities may verify the same, the antecedent, verify the said testimonials and release the aforesaid amounts to the petitioner within a period of 6 months from the date of submission of the same, full stop. The petitioner may accordingly obtain a certified copy of this order and furnish the same along with the application that has been directed to be submitted above. Yes, anything, Mr. Bob?
Instead of while successfully submitting, instead of directing all the respondents, finance just a proper party, but it will be the respondent number 5. Superintendent of
Five,
police.
respondent of 5, no issue.
He will be liable for it.
And Mr. Bora, you please advise that simply making the claim will not do. There may be other brothers, sisters, we do not know. But the entitlement as such is there. Who will get, you have to decide.
I'm opinion.
Okay.